Has been done. Why? Not done.
It was indicated, the OSG had called up the advocate on record. The advocate on record indicated that we are supposed to mention it before courtroom number 5. We went to courtroom number 5. The courtroom number 5 just now indicated, my lord, that he's sitting for only 1 day. Urgent determination is not going to take up the matter.
Who is the honorable judge? Honor which before which honorable judge it has gone?
Justice Shogadu Bhattacharya.
So you mentioned before.
Mentioned. He refused. He's saying he's there. He's got determination, urgent determination only for 1 day. That is today, and he's not going to take up the matter. Since we waited for 1 full week, he's not going to take up the matter. We are running from pillar to post. Had it been a quashing, we would have understood, my lord. When it's an anticipatory bit, my application will get
I understand, but
we are before your lordship. Whatever your lordship decides, my lord, that
it is the discretion of the concerned judge. On that, no administrative order can be sent. So, if I justice.
Your lordship assigns it to a particular court, then
But any order has been passed by no. So Banerjee, I tell you, there was an observation of Justice Ghosh that as it was extensively heard by his lordship, it should go there. That observation is there.
Yes, but if Justice Ghosh does not say,
in all probability, Mr. Justice Shenduk this much I can. Or you send the letter, let us see how.
Grateful, my lord. Or alternatively, my lord.
I think, Mr. Banerjee, I don't. That is your decision. If Justice Sengupta joins tomorrow, then there is no problem.
I never had a problem, my lord. That is the reason, my lord, we are categorically saying that on Monday we did not mention before any court. We did not mention before any court, thinking that, my lord, Justice Sengupta will resume. But in this thought process, my lord, the raids are happening at our house, and our application will become infructuous. The Justice Ghosh took the supplementary.
Consider keep this thing in mind that the regular bench will be coming tomorrow. Then whether you will wait for this day or tomorrow you will see the development and come and.
My lord, may I just then suggest something, my lord, subject to what your lordship. Yes. We will not give this note. Let us see tomorrow. If he does not,
yes.
If he does not, then, my lord, at 11 o'clock, my lord, we'll give the note. Then your lordship takes takes care of the situation, my lord, saves us, because then we will have the weekend also too. Grateful, my lord. Grateful.
My lord, this is contempt matter, my lord.
Our order?
No, my lord, Justice Choitali, my lord, I've given the letter of assignment.
It has been sent to the bench of which his lordship is a party.
My lord, may I kindly be...
Yes, Mr. Chatterjee.
May I be permitted to mention one public interest litigation? My lord, this is in connection with the NIT issued by the Kolkata Municipal Corporation for monetization of the land.
You meant motion.
My lord?
New motion.
Not new motion, my lord. There is an interim order which is given, but there are two other aspects, my lord. One, direction was given. My lord, inclusion, my lord, in the list, and this matter has some urgency. It's related to the monetization of the land of the zoological garden. That has been stayed, but my lord,
if the file comes, if the requisition is answered, we will place it in the monthly list.
It should be hard. There are two directions. Mayor should come up with the affidavit that under which circumstances he had exercised the extraordinary power.
Yes.
Review matter, my lord. The date has been fixed.
Review.
Yes, my lord.
Our order.
Yes, my lord.
Passed by my brother and myself.
Yes, my lord.
No.
Show us the order. Show us the order. What you are wanting, sir?
I am praying for fixing the
Give
date,
a notice
my
to
lord.
the other side. Give a
No,
notice to
only the date has been fixed on 3rd July 2026.
then why you
I am praying for time only, time schedule, my lord.
So tell us on third. If it appears, then you tell us. Yes,
Lordship, may I permitted to mention for Central Tribunal hearing matter.
hearing matter.
Hearing matter.
Wait for this week, sir.
Good.
Come next week.
2016 matter. The appeal is pending 2016.
So what were you doing for 10 years?
Next week.
You had no fault.
One
Hand over the slip.
application matter, the Union of India versus Moyuddin. It's a 2024. Only delay and submit the application.
Has it
No,
new
not-
matter? New matter.
No.
Give a notice to your other side and mention. Give a notice. Yes. Call the list.
I for the respondent.
Your Lordship, I'm appearing on behalf of the appellants.
This is, it has to be released.
My lord, my lord.
তাদের appearance গুলো নিয়ে।
Lordship, beg to withdraw, Lordship. May I, Millard, hand over the written instruction?
On totally matters. Due to
Five, my lord, are analogous matter, my lord. My lord, in this matter, I want to file a supplementary affidavit, my lord. That a document has come up, my lord, that has,
the affidavit, how can it be?
my lord, a document has come from the client, my lord, that has not been brought to the notice of the honorable tribunal also.
For that, you have to
My lord,
make an appropriate application. Supplementary will not help. It's a final disposal.
no, my lord, this is,
It's a disciplinary proceeding matter.
my lord,
So you have
my
to,
lord, one so-cause notice has been issued.
if you want to bring anything in on record, you have to make an application for that.
My lord, I file an application. That's why, my lord, some time adjournment I am required, my lord. My lord, 2 weeks adjournment, my lord.
And disciplinary proceedings.
Minor. Same.
Documents needs to be
তো করছে না ডকুমেন্ট মিস্টার learned advocate appearing for
Bidhayok Lahiri.
হ্যাঁ
Bidhayok Lahiri.
Lord, I appear for the respondent writ petitioner.
Lord, I am for the appellant. Index to the words. My lord, yesterday only I have handed over the list of judgments.
not given anything. Not sure.
But I had a point of maintainability of this appeal. My learned friend also raises a point of maintainability of his appeal. But I also have
only
a point.
he has filed an appeal, no?
He has filed an appeal. He has conceded before the court, before anybody raised any point of maintainability, that he has to cross the hurdle of Ramkishan Fauji. That is his self.
If so, raised by the respondents. Anyway,
But my point of maintainability is on a different
We
angle.
didn't follow the last line. What did you say? Maintainability point you took in.
no,
It
my
will
lord,
be done.
on the last occasion, I have submitted, my lord, that fine so far there is a judgment which is governing this field. That is Ramkrishnan Fauji, which otherwise directs a appellant to prefer a SLP against any order passed in connection with a criminal proceeding under Article 226. My lord, that is what I submitted. Subject to it is raised by the respondents.
So this issue has been referred to the larger bench by the division bench presided over by Justice Tandon.
And that matter is being heard in the 15 July in the fixed
I am told, my lord, that the larger bench is to reassemble on the 15th of July to hear that matter.
And my lord, the other point,
15th of July.
15th of July, this month.
So, you show us that order, Mr. Dotto.
my lord, the other point raised by the respondent, Mr. Dotto, is so far the maintainability is concerned.
Let us just check it up whether it is 15.
It is there on my iPad.
What was the reference, Mr. Dotto?
My lord, reference was, my lord, if the writ court passes any আছে তো কাছে
পুরো সেটটা
ও না রেফারেন্সটা দেন
If the
রেফারেন্সটা বের করে দেন না তাহলে give me a moment. রেলেভেন্ট জায়গাটা বের করে দেন
My lord's leave, can I hand this up to your lordships?
রেলেভেন্ট জায়গাটা বের করে দেন
usually cannot handle expensive gadgets.
No, my lord, this is 4 years old.
Yes. If your lordships are, my lord, looking at, my lord, the order.
আমি রেফারেন্স জাজমেন্টটা দিচ্ছি
এটাই তো
টান্ডন জাজমেন্ট
Order dated 29 November.
এটা তো
Tandon সাহেবের জাজমেন্টটা আছে। Tandon সাহেবের জাজমেন্টটা দাও।
This was the single judge's order.
No, this was subject to correction. The division bench judgment presided over by my lord Justice Tandon, where, my lord, the larger bench was, my lord, requested to be
Which
constituted.
paragraph the reference?
Well, I'll just mark that for your lordship, my lord. I'll mark it for your lordship. I'll mark it for your lordship.
My lord, the point of reference,
Tell us, sir. Tell us. Read.
whether an appeal under clause 15 of the,
এটা তো this is deciding in one way, Justice Talukdar's division bench in another way, and Justice Tandon referred it. Not this one.
Tell us, sir. Tell us.
My lord, should I read it out?
Yes.
I read it out. My lord, with Mr. Dotto's view, my lord. The certainty of law is a virtue. Two conflicting decisions operating simultaneously in the field of law should be avoided and should not be permitted to operate in the same field. In order to eradicate any conflicts in this regard, and being the coordinate bench, we feel that it would be proper and appropriate to refer this matter to the Honorable the Chief Justice for constituting the larger bench to answer the following reference. 1. Whether an appeal under clause 15 of the latest patent is maintainable against an order passed in exercise of powers conferred under Article 226 of the Constitution of India in relation to a notice issued under Section 160 of the Code of Criminal Procedure to be regarded as an order passed in exercise of the criminal jurisdiction, or depends upon the nature of the order ultimately passed in a proceedings as indicated in Gopal Kumar Agarwal and another Supra. We therefore direct the instant matter to be placed before the Honorable the Chief Justice for constituting a larger bench to decide the point of reference as
So the what we heard is that issue is whether a writ petition
Appeal. Whether an appeal under clause 15 is maintainable.
is maintainable on whose behalf? The de facto
Anybody's.
Anybody's behalf, whether an order passed by the writ court in exercise of criminal jurisdiction could be challenged under clause 15 of the latest patent before by way of an intra-court appeal. This is the point of reference. Because why? Because there are two conflicting decisions of our court. A division bench presided over by the then Honorable Chief Justice Radhakrishnan held that an appeal is maintainable, and another division bench presided over by Justice Talukdar, Justice Subroto Talukdar, held that it is not maintainable. Now, in view of these two conflicting decisions, Justice Tandon has referred the question to the larger bench. The larger bench has been constituted.
Issue of whether an mandamus appeal or whether a clause 15 appeal is maintainable, then what did you say? What against what?
Against an order
Yes.
passed in exercise of powers under Article 226.
Against
relation to a notice-
against an order passed in exercise of
Powers under Article
Criminal jurisdiction.
226 in exercise of criminal jurisdiction.
লিখেছো?
Now, my lord, the larger bench has been constituted of Justice Orijit Banerjee, Justice Hiranmoy Bhattacharya, and Justice Om Narayan Rai. But I'm told, my lord, the honorable larger bench is in CC over the matter. 15th of July, bolli na? 15th of July, the honorable
Involved in the present
My
appeal.
lord, though the point of maintenance taken by Mr. Datta on the last occasion as to the locus of the present appeal
Effect to complaint.
of the law. Now, my lord, I am ready with that.
May I say this, my lord?
So, Mr. Jana, to cut short the matter, we will be keeping it on a day subsequent to that date. If the point is decided, then it will be a futile exercise on our part to give. Let the
My lord,
special bench.
so far our maintenance point is concerned, my lord, it is little different from the point which has been referred before the larger.
But it is a clause 15 appeal,
It is a
which we are hearing.
yes, it is a clause 15 appeal, my lord.
Your may be factual differences, or you may have fresh arguments on that. That will also be taken into consideration by the special bench, because without that they cannot proceed also, subject to correction.
My lord,
We can go and address the special bench also on
Pardon?
this issue. We
can send this petition to that special bench
That
also.
also can be done, subject to your lordship's consideration.
retrospective act. You just did.
Okay.
My lord, only predicament which I feel is that, my lord, even if whatever judgments is pronounced by the larger bench, even, my lord, if it goes in favor of this appellant, then also the other point raised by the respondent, by Mr. Datta, about the locus, relating to the locus of the de facto complaints preferring an appeal, my lord, that remains.
No,
we
that
don't
can't,
know,
because there are
appeal is
2
not
points.
applicable.
Jana, we don't know, because you will be there, I think. In that matter, you are there.
No, I am not there, my
So
lord.
naturally, this point will be argued that this complaint has been lodged. Then there has to be a returning of finding that no de facto complainants, because
Right.
it's a special bench points. Hopefully, those points will be taken, and you are there, Mr. Datta, in that matter.
My lord, keep
Special
this matter open then, keep this. Because, my lord, and other
No,
thing
we
which
will simply say that there is the issue involved has been sent up in reference in a special bench, which is due to be reconstituted on a particular date. We keep it 1 week.
1 week thereafter. Very good.
Or we can.
ঠিক আছে।
আচ্ছা।
15 July at 3:30 p.m. That matter is fixed.
The issue involved in
No,
My lord,
he has come.
even that is also
He
not
is in
my
appeal.
grievance.
In the writ petition.
In the writ petition.
Investigation is by the police authorities.
Yes,
Now, a de facto complainant cannot be ousted from that. That
we are not saying
After
that.
Jagjit Singh's judgment.
We are not even saying that. He had appeared, he had made his submissions. His submissions.
Chatterjee, suppose that it is there is no sort of we cannot say when the special bench will return the finding.
Lordships. No, my lord.
Way or that way, that does that mean that till that issue is considered in the backdrop of the facts involved there, can lead to suspension of hearing of all mandamus appeals which are filed.
My lord.
Then he is also not a party. You are also not.
Lordships. My lord, my respectful submission was that so far as this matter is concerned, my lord, Mr. Jana, his primary grievance is the order
That we will
No,
hear.
no, I don't get any
protecting me from
pleasure in
arrest.
getting a
Allow
person
us to hear,
arrested.
we will hear.
Lordships.
But you are saying that don't hear. Because there is judicial propriety, judicial discipline also
My
decides.
lord, in fact, your lordship will recollect, my lord, when Mr. Jana had opened the appeal on the first day, my lord, it was him who had, my lord,
Yes.
indicated. It is not us that we started with. But since, my lord, this issue is there, my lord, we cannot, my lord, perhaps also deny that the matter is before the larger bench. So, my
My
lord,
lord, I cannot.
your lordships will take a call.
When I am before this.
So far as my client is concerned, my lord, we are in the hands of your lordships.
We have adjourned it till 29th. On 29th, if the issue is not decided, then you can make your arguments that for disposal of that you cannot indefinitely postpone a hearing.
I'm extremely grateful.
So
My
that
lord,
that
is
you
what,
assist us.
my lord, that is exactly where, my lord, and one
Or
more.
we can say we will simply not pass this order. We will simply adjourn the matter till a particular date when it is 15th is fixed.
No, let this order be there. Let this order be there, my lord. We will come back on 29th.
And
in
we
the
are
meantime,
complying.
if anything happens, my lord,
After
we'll inform this.
after the order passed by the honorable single judge, twice my client was called by the police, my lord, and on both occasions, my lord, we have complied with the
My
notices.
lord, that is why I am saying, my lord, now the claim of the respondent will be that I have incurred a right because I have complied with the honorable court's direction. But my lord, I must kindly allow me to make it clear that I don't get personally don't get any sadistic pleasure in getting a person arrested, and that is also not my grievance. I have challenged the legality of an order passed by a single judge because there are category of judgments of the honorable Supreme Court as well as these honorable courts also, and there are guidelines framed that as to when an order can be passed. An order directing police authority not to take a coercive action, sitting in a
subject to this, if the special bench in course of hearing appreciating that issue that when we will decide, that will not prevent the other coordinate benches to take up.
And the issue there is different, my lord, actually. My lord, there is a 160 notice.
Set of facts. Different set of facts. But the issue is maintainable.
Legal issue is the maintenance.
Legal issue is this on a different set of facts. Exactly.
Right. You get that clarification. We will hear. But you are not a party to that.
I am not a party.
So we can simply adjourn it without recording this fact.
Exactly. Kindly let this order remain, my lord. We will come back on 29th. In the meantime, if anything
We will
happens,
keep the order.
we'll inform.
We will
Yes.
Lordships keep the order.
Right?
I am deeply obliged.
Neither me, neither Mr. Chatterjee will sadistic pleasure in getting a person arrested.
29 এর আগে এসেও তো আমরা মেনশন করব।
For the writ petitioner appellant.
I am leading Mr. Bhattacharya.
This is my affidavit of service. But before going through the order impugned, Your Lordship, allow me to place the brief facts of the case.
Non-answering response. বলতে
obstructed me.
Why?
According to them, I am encroaching their mortgaged land.
PNB's property.
I moved a writ petition,
So you purchased it from whom?
State Bank of India, auction. This is also through auction,
First through surfacing.
my lord. Now, my lord, I moved a writ
So it
petition.
was a auction of the recovery officer.
Yes.
On that you purchased it.
I purchased
Very good.
on bank PM. Then I moved a writ petition.
Now who claimed to be the owner?
So far my property is concerned, there is no dispute. So far my ownership is concerned. According to them, the adjacent land that has been mortgaged to the PNB, and I am encroaching that mortgage land. Their grievance is that. Now I came before this honorable court. Learned single judge passed an order to demarcate the land of all the parties in their presence. That demarcation has been done in their presence. Demarcated order has been handed over to all. After demarcation, again I sought to raise construction.
The demarcation was on the basis of court's order.
Court's order.
Right.
Then I again sought to raise construction. They again obstructed. Again I came before this honorable court. One of the learned single judge passed an order directing the police to render assistance to me so that I can raise construction. You will have to just go through just two paragraphs of the order.
What was your prayer in the writ petition?
Subsequently, this order has been upheld by the division bench, whereby the learned single judge allowed me to raise construction in terms of the demarcated order and also directed the police to render assistance. I constructed the boundary wall. They preferred an appeal. Appeal has been dismissed. Just two orders, if your lordship kindly allow me to place before your lordship. Kindly turn to my lord, page 72.
Mine is the 7th June 2025.
My lord, that is my lord.
Page.
My lord. Page, my lord. 7 টা কত হলো? ওই যে পরের অর্ডার।
7th June 2025 order.
Just I'm giving. Page 87.
Page 87.
This was the order in your first writ petition.
Well, that is 83, page 83.
87.
83.
This was the order in the first writ petition.
No, this is my present writ petition, which is pending.
Pending writ
My
petition. It is. What is the operative? But in the meantime, concerned police are directed to provide adequate police protection to the school. No further demolition of the boundary wall take place.
83 মানে 96
83, 17 June.
Yes.
Now, I will also kindly just see one order of the honorable division bench. Kindly come to my lord, page 76. But this is an order passed by the division bench where the Punjab National Bank preferred an appeal
Against which order?
against the order passed by Justice Sengupta, Joy Sengupta, allowing me to raise the construction in terms of the sketch map, and police has been directed to render police assistance to me. Kindly take note of page 76. This is an appeal of the Punjab National Bank. Your Lordship may come to
No, then first show the order impugned in that appeal.
in this matter.
No. In
My
page
lord, my lord. Page 73. I want to raise that order first. Your Lordship may come to page 75, the operative portion.
the writ court order.
My lord. It starts from page 73, 20th of December 2022.
So this was the order in the writ court. You show vis-a-vis this, what was your order in the writ petition? That writ petition is here? No.
No, writ petition order I am showing before Lordship, page 73.
Yes.
Page 73, kindly turn to page 75, the operative portion.
This is the same order.
No. 75 is the order passed by Justice Sengupta. May I read, my lord? Page 75. I have heard the submission of the learned counsel appearing on behalf of the parties and have perused the writ petition and the report filed by the state. It appears that land in question has already been demarcated by the competent authority, and this has obtained a stamp approval from this court. It also appears that the petitioner could fairly entertain an apprehension that if they tried to put a boundary wall in respect of their land, there could be a possibility of breach of peace. In the interest of justice, I direct the respondent authorities to ensure that no breach of peace takes place if the petitioner tried to construct boundary wall. All the demarcated line, if necessary, sufficient police protection will be provided by the officer in charge, Jaipur Police Station, at the cost of the petitioner. In terms of the order, I raise the construction. Now, Punjab National Bank preferred an appeal against that order. Kindly turn the page 76.
19th of April order.
My lord. Kindly turn the page 77, paragraph number 4. After notice. Sentence starts, after notice to all parties, including the appellant bank, the said authority has passed an order on 29th August 2022. This is the demarcated order, a copy of which has been annexed to the affidavit in opposition filed on behalf of the respondent number 1 and 2. In terms of the said order, the demarcation has been done, and the said authority in this order records that at the time of hearing, all the parties submitted their deeds, including the Punjab National Bank, and the process by which the map has been processed has been explained before them elaborately. The appellant bank appears to have challenged the order passed by the Block Land and Land Reforms Officer on 29th August 2022 by filing a writ petition in an indirect manner by questioning the disposition. However, this order having been passed in August 2022, the said order has not been stayed or varied till date. As long as the said order remains, kindly take note of, intact as on date, the order and direction passed by the learned single bench for construction of the boundary wall at the demarcated line cannot be interfered with. However, we make it clear that since the appellant bank have already questioned the correctness of the order passed by the Block Land and they have also filed a writ petition, it will be open to the appellant bank to canvass all points in the said writ petition and seek for appropriate orders and direction therein. Therefore, at this juncture, we are not inclined to interfere with the order of the so-and-so. Accordingly, the appeal is dismissed. But in terms of this order, their pending writ petition was taken up for hearing, which has been filed by the Punjab National Bank. You will also kindly turn to page 80.
That is after the appeal court?
Yes,
order?
yes.
What did they file challenging what?
They have challenged the demarcation.
Oh, I see. The demarcation.
My lordship, kindly come to page 80.
After disposal, after the appeal court order, they
filed it prior to appeal court order. That was not processed. Subsequently, that has been taken up for hearing by the learned single judge. It was filed prior to appeal.
Page 83.
Page 80. Kindly turn the page 81. One paragraph.
81.
The demarcation has never been interfered with by any other.
Where you are reading?
Page 81.
81 why? 81
it starts from page 80. The order passed in their writ petition, it starts from page 80, order dated 26th of March.
Reflects.
My lord. Paragraph 81, page 81.
Page 81,
Second paragraph.
second
The
paragraph.
previous report reflects that the demarcation has already been completed. Accordingly, the portion of the demarcated property for which the claim has been presented by the petitioner Punjab National Bank and the schedule referred to in respect of the owner so-and-so, Mr. So-and-so, given effect by the police authorities in accordance with law. So, my lord, demarcated has not been interfered with. Now, what happened, my lord?
We are not so fast like you, Mr. Sir.
Sorry, my lord.
ঘোড়ার মতো দৌড়চ্ছে।
Now, my lord, they have demolished the considerable portion of my boundary wall.
Again demolished.
Again demolished. I came before this honorable one second. If you also kindly come to page 83. This is very important, page 83.
Page
83. In our absence, boundary wall, almost entire boundary wall has been demolished. We have not been intimated even. Now I again filed a fresh writ petition. That is page 83, the first order. Kindly take note, pen to go through this order. Entire thing has been recorded at page 83.
No, but you did not.
Demolition of sketch map, all photos I have annexed. I shall show to your lordship. Kindly take note of page 83. May I read, my lord? Page 83.
Page
83. The order passed in there, in terms of the present writ petition. Petitioner have approached this court with the present writ petition entirely questioning demolition of part of boundary wall, which has been constructed by the petitioner in terms of the order dated 20th December 2022, passed by a coordinate bench on a writ petition being WP number so and so. It is submitted that based on demarcation of land possessed by the petitioner by order dated so and so, petitioner approached this honorable bench. Order was passed on so and so, directing the respondent authorities to ensure that no breach of peace takes place if petitioner constructed boundary wall around the demarcated plot in question. Coordinate bench also directed, if necessary, sufficient police.
Page 80. You are reading page.
Page 83. I start from page 83. Now I am in page 84.
Yes.
After demolition, I moved a writ petition challenging such demolition, and this order has been passed. May I read from page 84?
Yes.
First paragraph, directing the respondent authorities to ensure that no breach of peace takes place if petitioner constructed boundary wall around the demarcated plot in question. Coordinate bench also directed, if necessary, sufficient police protection would be provided by the officer in charge Jaipur Police Station, Bakura. According to the petitioner, order dated so and so was questioned by Punjab National Bank in an input after just I have placed before your lordship, which was dismissed by the Honorable Division Bench by order dated so and so. Therefore, according to the petitioner, since order dated 20th December 2022 was not interfered with by the Honorable Division Bench in connection with intra-court appeal being MT number so and so, respondents ought not to have demolished part of the boundary wall erected by the petitioners in terms of the order dated so and so. Bank authorities respondent number 9 and state respondents are represented. All are present by learned advocate who have opposed the prayer of the petitioner. Report has been filed by the officer in charge Jaipur Police Station, Bakura, dated so and so, is taken on record. Having considered the 85. Having considered the respective submission made on behalf of the parties, it appears that nothing is on record which goes to show that demarcation order dated so and so passed by the concerned block land and land reforms officer has been varied or set aside by court of law or any appropriate authority. Therefore, court needs to proceed on the basis of the demarcation order dated 29th August 2022, taking into notice of the. Well, your lordship has already gone through the order.
Yes. Now, what do you want?
I want repairing of the boundary.
Said that they ask the police authority to ensure no further development, demolition of the boundary wall take place.
Yes.
So further demolition has been prevented.
Yes.
Now court has taken note of this fact, having regard to.
Yes.
Court has taken
now the
note
situation,
of everything,
my lord,
that BLR's order and the division bench did not interfere with that order, whereby liberty was reserved to you to construct the boundary wall. Now what do you want? Court is the
before that, just one document I shall show to your lordship. In terms of this order, the police officer sought for a further report so far the demarcation is concerned from the BNL. Review your demarcation, which has been upheld by the division bench.
Police officer, police and state has been asked to file another report.
Kindly come to page 87. What is the report?
Yes, come to, in view of the order, you come to page,
Your Lordship, page 87.
last portion of 85.
Yes, I have seen. In terms of that order, report has been submitted. That is page 87. What help?
Report was submitted, but in the report, no explanation is forthcoming in this
Yes,
matter.
then next
It
portion.
is the observation
Yes,
of the court.
kindly come to next portion.
And now next portion.
Yes.
Now, learned advocate representing the state respondent has paid for accommodation to file another report to explain the situation where part of the boundary wall has been demolished.
Previous report was bogus, as such court did not accept it. Further report has been sought for. Now the report, page 87. How and which manner police authorities are proceeding? Kindly take note of page 87. How the demolition has been taken place. May I read, my lord? First paragraph, in accordance with the order. Then, on May 17, 2025, as per the order dated so passed by the Honorable High Court, Calcutta, officers and forces of Jaipur Police Station, as per the assessment cost paid by the Punjab National Bank, the Punjab National Bank officials, joint video Jaipur, and a private surveyor, kindly take note of. Amin is deputed by the Punjab National Bank, arrived at the premises to assist Punjab National Bank to take possession of their assets. This is in our absence. Accordingly, in good faith, kindly take note of. Accordingly, in good faith, Punjab National Bank, in the presence of the joint video, took possession as shown by the Punjab National Bank officials and other surveyors as per the demarcation report, for which some portion of the boundary wall was demolished. As the entrance gate of Ma Jagat Gori Rice Mill, my other property, was dosed by the boundary wall, and as per the statement of the Punjab National Bank officers there, so there was their property, they had to break the show. So as per their demand, as per their boundary wall has been demolished in our absence. Kindly take note of the last paragraph. As per the kind order of the Honorable High Court, Calcutta, regarding the deployment of police protection, so that no further so. The next line, I submitted a requisition to the BLRO, Jaipur, for assistance to find the Punjab National Bank had taken their asset as per demarcation or not. But this good office replied that they are not in a position to demarcate. Kindly take note of the next page. He sought for a resurvey of the plot of land. The officer in charge.
He sought for
resurvey of the plot of land, which has been upheld by the division bench. Kindly turn to page 88. Fresh demarcation. No court interfered. Division bench upheld. Kindly turn page 88. Have a lordship got pen?
Just a moment.
Prepared for resurveying the map of PNB land acquires at the asset, addressing to the block land and officer by the officer in charge. To resurvey, to redemarcate, upheld by the division bench. And suitable answer has been given by the BLRO. Kindly turn the page 89. All cases has been referred. First, subparagraph A, B, C of paragraph 1. Kindly turn to paragraph 2, page 89. The WP number so-and-so, Calcutta, observed that the earlier orders culminated in the order till so-and-so, indicating that the demarcation of land has already been done. It appears that the land in question has already been demarcated by the competent authority, and this has obtained a stamp of approval from this court. In the WP number so-and-so, it appears that nothing is on record which goes to show that demarcation order till so-and-so passed by the concerned block land and land reforms officer has been varied or set aside by any court of law or any appropriate authority. Next page. Taking note of the observation of the demarcation order dated so-and-so, Honorable Division Bench ordered that as long as the said demarcation order remains in force, the order of direction passed by the coordinated bench on so-and-so for construction of the boundary wall at the demarcated line cannot be interfered with. Keeping in view of the above judgment, it is evident that the matter is same in every order passed by the Honorable High Court, and following the reasoned order passed on so-and-so with demarcated sketch map, undersigned is not in a position to make assist regarding resurvey of the land.
Maybe yeah, it is the communication in between the
Absolutely.
police authority and BLN.
But I want to say the police.
Now, you wait what report the state submits before the court.
Yes, this is the report.
You are seeking intervention of the division bench at this stage.
I seeking an order. I came before the honorable court by way of filing an application to allow me to repair the boundary wall. That matter went up to the division bench. Division bench says, since in the application there is no prayer for repairing, I am granting you liberty to file a fresh application. I filed a fresh application in the pending writ petition. The learned single judge refused to pass any order allowing me to repair the boundary wall. That is under challenge before your lordship. I cannot run my business. I cannot place any trucks therein. My godown, cold storage, rice mill is totally closed.
Who has the order in now?
Page 222. Triple. Entire business has been closed.
Page.
222. In terms of the division bench order liberty, I filed the application.
Where that liberty was given?
Kindly
Terms of the division
previous page. Page ballot 220.
220 is the
Order of the division bench. In my application,
this appeal was against which order?
I filed an application praying for repairing of the boundary wall. That application has been entertained, but no order has been passed. I preferred an appeal against that, praying for repairing of my boundary wall. The Honorable Division Bench granted me liberty by saying that since your application there was no prayer for repairing, we cannot consider. And I have been granted liberty to file a fresh application. I filed that fresh application. Learned Singh Judge recorded everything, but refused to pass any order allowing me to repair the boundary wall. My entire business has been closed. I shall show to your lordship the pictures.
So you want to repair?
Only that one.
But there is
according to the demarcation.
But there is no existing wall now. Everything demolished.
Demolition. Part portion has been demolished.
Part demolished.
Part demolished. That's the observation of all the courts. They have taken their property, including my property. Today, this is a criminal gain.
So show us the order.
Division bench order, page 220.
No, that, the order impugned before us.
222. Kindly see the paragraph 2A. What was my prayer before the Learned Singh Judge?
So the court proceeded on the basis that the writ petition primary prayer is to repair. And if I pass this order at this stage, you will be getting a protection at an interim stage in the form of a final writ.
To some extent, this is the observation. To some extent. And further observation is that already there is an order upon the police authorities to protect my business. But how can they protect?
All things taken away.
All goods.
Right? Today, suppose we are wanting to ascertain now what is the position. There is
the position is that boundary wall is there. Some portion they have demolished. Every person is going and coming from that purple. We have no access to that. We have no privacy, nothing. We cannot place our vehicles for unloading, unloading.
Ingress and ingress has been stopped.
Yes, now their persons are staying there. The Punjab National Bank engaged.
Then the boundary wall was constructed originally by whom?
By me. As in terms of the court order, according to the demarcated, I am praying an order to repair.
When did you do that? When did you do that? When did you rebuild? You are saying
there was no boundary wall. I built the boundary wall in terms of the order passed by Justice Sengupta, Judge Sengupta.
Show us again Judge Sengupta's order.
Page 73. Page 75 is the upper portion. According to the demarcation map, I have constructed the boundary wall. Today, I shall go there in presence of PLR or police officer. I shall repair the same in accordance with the demarcated map, which has been prepared in their presence. They have not objected to the same. None of the courts interfered with the same. Till today, it still stands. Let all the presence of the statutory authorities, presence of the Punjab National Bank, I shall repair it. That's my only prayer.
Mr. Sarai, that becomes your final relief. Then nothing remains.
Well, relief, so far my REIT is concerned, that is entirely in other respect because they have taken all my goods.
No.
After demolition.
Your prayer which has been quoted in the.
That is in my application. That is in my application, not the REIT petition.
Very good.
Yes, page 222.
So then this application which was disposed of, the Can 3 is placed before
Yes.
for consideration of the relief.
This is the prayer of the application.
This prayer, in fact, is the main prayer in your REIT petition.
My prayer in the REIT petition that the demolition which has been done.
Where is that prayer portion of the REIT petition? Is it page 59?
Just I think.
No. It's an application. I think page 36.
Page 15.
Repair. Page 36 is the original prayer, no?
My lord.
Now you compare prayer A with prayer A as quoted at page 222. Your prayer of the application. An order to issue.
Kindly come to my lord.
Demarcated property as demolished by such and such.
36 is not the prayer in the writ petition.
No.
Writ petition is not annexed.
This is the prayer, page 36.
The prayer in the can.
Can. It's a can.
Not the prayer in
Petition has not been done.
Please give a copy of the writ petition. No, this is the prayer in the.
Because
Mr. Sadayo has.
that I filed before the learned single judge. Since the REIT was there, I have not annexed the REIT petition.
No, we understand.
Just see the prayer in the writ petition. This is the prayer 12570. Copy nahi.
Previous appeal, when I moved, the division bench asked me, where is your prayer for repairing? I submitted before the division bench, that is my plain prayer in the REIT petition. You go file an application making specific prayer for repairing.
Was the reasoning of rejection by the court against order against which you have come to us?
That is page 222.
But we stopped you when we were placing.
My lord.
Yes. Now show us the order.
My lord. The prayer has been quoted at page 222. Now your lordship kindly come to page 223. Paragraph 5, the submission of my learned friend recorded. Then the operative portion, page 224.
Yes. See,
having considered, paragraph 7.
Go further. Having considered the prayer couched in the bill, then no
unless I
to be passed at this stage, taking of the order passed by this court on 17 June 25 is which page?
But that is page just
page 83.
83.
No. But we have something for your lordship. A compilation of all orders. Your lordship find 17 June. I am handing over a copy to my learned friend also.
83. Well, 83.
Please. 17 June is there.
That is page 83. Oh, paka.
কি ধরি হচ্ছে বিভিন্ন জায়গা থেকে দেখো তো তোমার কম্পাইলেশন করে দিলাম অসুবিধা কি সেটাও পাকামো
ভালো
Is asked how.
And in the compilation, it's page 34.
দিয়েছে 83 থেকে।
Print করলাম দেয় কখন কম্পাইলেশনটা দে তোকে আমি কপি
But they have posted security guard in my premises, the Punjab National Bank,
কপি দিয়ে দাও না
within my premises. Kindly take note of. Now it has become a criminal den. Loading, unloading of trucks, goods.
Keeping in mind
Kindly see the pictures, page 193 onwards.
order passed in earlier round of
Yes, what you
I have annexed the all photos. Kindly take note of 2-3 photos. It starts from kindly come to page 195, 197.
সেটা ফ্রেশ সার্ভিস সেটা সেটাই সেটা আমরা লিখতে পারি কিন্তু সেটা কোড
কোর্টই তো বলেছে রিপোর্ট ফাইল করে
রিপোর্ট ফাইল এখন স্টেট সাইড ফাইল
But kindly
in these circumstances actually
see 2 photographs just. I have annexed all. How today, what is the position? Page 197. This is the truck engaged by the Punjab National Bank within my boundary. Page 197. All goods are being taken away. That's my final pair in the repetition. Page 197, 198. I have no access to my premises. Upheld by the revision bench. Kindly see 199. These are people all engaged by the Punjab National Bank after demolition of some portion.
So you are operating any business there?
No, I am my cold storage, rice mill, all closed.
But
Stalled.
then if the boundary wall is repaired,
Yes,
suppose you get
yes,
that,
yes.
how that will help you? It remains closed.
None will be allowed to enter.
Then
The
how
parking
how
of
will it
vehicle.
benefit you, Mr. Shara?
Today, if I park a vehicle within my premises, at the night,
I don't know that. Suppose today you are saying that you allow us to reconstruct,
Repair.
repair the boundary, reconstruct the boundary wall, which has been done on the basis of a demarcation report filed in presence of their authority. We are just wanting to know now if the boundary wall is repaired. You are
there is a gate. There is already a gate.
very good.
The vehicles can enter in my under custody.
Now that
I can load, unload.
this ingress and egress way, that is whose property? Is
My
that
property. They are not disputing the same. So far my gate is concerned, gate is still there. Some portion demolished, goods taken away. Now every people is coming there. This
By
is a
the bank, goods taken away by the bank.
bank. There's the pictures.
Have you filed any FIR?
There is another proceedings in respect of the other property. That FIR, numbers of FIR.
If by
Kindly come to 215 onwards.
demolishing boundary wall, your goods are taken away, then they have
215.
they have committed a criminal offense.
215, that is also there. That is my
Filed, whoever may be there.
my lord.
No, don't say it is this conduct of the bank is not at all acceptable. Why are you taking law in your hand? If it is true, such a sort of allegation, that bank has demolished a wall. You wait for the verdict of the court. Do it according to the law of our land. If you have any claim on any portion of the land of the petitioner or appellant, then the law is there.
But kindly see page 215 onwards, all complaints.
Mr. Bhattacharya, we are asking you, suppose today if the repair work is done, suppose, how you will be prejudiced? We are not touching the fresh survey report, though there is grounds, the prima facie arguable case. Now, if suppose this repair work is done, how the bank will be prejudiced? Will that create any extra right in their favor? This is our question to you.
What my learned, if he has completed, I am answering you a lot.
Yes.
This is an order passed in.
First answer our query, then you proceed.
My answer to your lordship is, the first of all, the pinning down the bank with the effort. If they say their allegation is,
please give an answer to our
if
question.
their allegation is that we have broken, that is one thing. We want to,
No, you are a financial institution having an adjoining plot of land.
No, we have also parted possession of that to someone else.
We are wanting to. We are not saying that whether his entitlement will come later. Whether we are asking from you, if the repair work is done, how you will be paid.
Let him repair his own boundary wherever it is. We have got nothing to do with his boundary. His plot of land, let him do it. He is
not his plot. That
plot is, that is there is a dispute. There is a dispute.
Dispute for what?
Dispute, Milord.
After it was confirmed.
Attempted encroachment. Attempted encroachment.
A report was prepared in your presence. When the report was placed before the appeal court said very good.
But now whatever the boundary wall that they have sought to construct, according to us, is not as per the findings of the BL and LRO.
So very good. You will demolish it at their cost. At their cost, it will be.
In the presence of the BLRO construction.
What is your interest? Tell us. We want to know that.
Then I have
what
to.
Is your interest?
I have to. What I.
Mr. Bhattacharya, this is our boundary line. Suppose there is a wall.
Yes.
I am a disputed owner. You are a disputed owner on both sides of the wall. Suppose good, bad, indifferent. Somebody has demolished a portion of the wall. So we will be saying that wall, this repairing purpose, we will give it to you.
Milord, if today, Milord, his property is this, my property is this.
Right.
There is a boundary wall, I have no problems. If this boundary encroaches on my land and my goods, vehicles,
that will be considered in the writ petition. But today,
what is to be today
for safety purposes also, somebody from that side also can come in your bank's property.
The attempt is, Milord, a picture is being sought to be painted before my Lord Justice Chatterjee's questions, Milord. I was listening to it with rapt attention, Milord.
No,
Mr. Visualize.
Don't go. You have not answered our question. We are saying that
there is a portion which belongs to them. Let them repair whatever they want. They cannot repair on our land.
The boundary wall exists.
The boundary wall was constructed by them.
So as per that good, bad, indifferent, that action has been affirmed by the division bench.
With respect, no. With greatest of respect,
Exactly,
no.
that is an arguable issue. You will argue that in the writ court.
My lord, with
We are only saying that for the mutual safety of the parties, bank as well as them,
everyone is safe there. There is no, my lord, safety
we will
issues.
say,
My lord, the police is ensuring, my lord, in this writ petition. This is not the first.
Yes, sir, what is your problem if the wall is reversed? Will you
My lord,
be
when we
prejudiced?
wanted to take out goods,
No, no, how will you be prejudiced? We are asking you.
Well,
We have
we-
not passed the order.
BLRO demarcation করলো তখন
We
কেন objection?
have
Now when BLRO demarcated the land,
that happened in 2022.
okay, it was that demarcation was done in your presence or in presence of your representative. Then you have not made any objection.
Well, we have not. We are not disputing the.
So
demarcation.
therefore, you have no prejudice, no injury regarding the grievances regarding that demarcation.
You know, just you know, your
That demarcation was impliedly accepted by you.
Lord,
We are not going in. Suppose my brother has pointed out certain things. We are not entering into that. Resurvey, whatever happens, so that will be valid resurvey or not, etc. These points writ court will consider. We are only saying because writ court has said that I am calling for a writ.
if a boundary is constructed on my land,
Please take a written instruction. Otherwise, if we pass an order covering the issues, maybe that
I need to show your lordship something below before your lordship passes any order. I shall come with pictures. I shall come with written
No,
instructions.
no, we will see each and every document you give. But I am
document.
no, this is a simple question. Bank property, his property. There is a dispute. Court has dismissed his prayer for reconstruction on the ground that this might tantamount to grant of a final relief. But we are asking you, sir, what is your problem if the repair is made? That same wall will remain repaired. Now today, after writ court hearing, it is found that the wall is illegally constructed. That will be broken down at their risk and cost.
That the writ court perhaps may not be, kindly pardons me, may not the scope of a writ petition. It cannot be converted into a civil dispute with the parties.
We are still not getting your answer.
My answer is they cannot. They have constructed a boundary wall on someone else's land.
That is to be adjudicated after the
That
court
is
has
to be
done.
adjudicated. We have taken steps.
Ashok.
Your lordship will kindly permit us. I want to show your lordship something. Your lordship will kindly permit us to first return with instructions. Since it fell from your lordship.
We are repeatedly. It seems that you are not with that instruction, Mr. Bhattacharya.
I cannot concede to a thing.
I am not asking you to concede.
Your lordship will kindly. I may be incorrect. I may be incorrect, my lord. I am trying to, my lord. I am not trying to bypass the issue. The issue is, my lord, this writ petition is not the first writ petition. This writ petition is perhaps fourth in the, my lord, ladder of the writ petitions. I had independently, my lord, wanted to take out my goods from the portion which belongs to me. I had to come to your lordship's court. Your lordship's court granted me protection in the month of February, allowing me and my person
before demolishing what
not demolition
from coming.
No demolition.
These allegations come in this way against a financial institution.
With respect, no. With greatest of respect, no.
Yes, Mr. Bhattacharya, choice is yours. If you say that I will take instruction on that point, come back tomorrow in the morning, we will hear. But if you want to argue on that issue, please understand our question, Mr. Bhattacharya. We are wanting that if this repair work is made, whatever says, we will adequately protect you. We will say that ultimately the writ court finds that there was an improper construction. Bank authorities should be given an opportunity to demolish the entire property.
May I just show your lordship?
It's a question of person is running business.
He is not. He is only attempting to encroach on someone else's property and grab the entire plots of land in the garb of filing writ petitions one after the other. I put this question to myself, this is not the first attempt. Kindly seize his attempts. Please see 17th June order.
Will you answer our query or you will argue on that? We will hear you. We want that, see, these problems need to be settled. Technicalities of law, if we prima facie find, after a survey report was made, That was confirmed by the division bench, and on that basis, a construction allegedly has been raised. Where
Just one thing I need to show, then thereafter I shall come up with one instruction, whatever
so
instructions
you
you
come with the instruction.
just allow me to show your lordship only
One
two
order.
things, and I'll stop. Two things I'll stop. Please see me not the compilation that I've handed over to your lordship.
21 and 22, page 21.
Not 17 June 2025 order is the first in the at the point of time by this honorable court, granting them adequate protection. Then, my lord, 10 September order in the same writ petition, where a coordinate bench.
10 September.
Yes, my lord, that is 10 September order is at page 38.
How you have made the compilation? 38.
Yes.
Yes.
My lord, it is in the same writ petition. The first order was 10 June 2025. This is 20th September, 10 September 2025. It is admitted, my lord, I am reading the last paragraph.
What is this first one?
The first one is the
Justice Shampa Sarkar?
No, my lord, Justice Bhattacharya.
Which order you are showing us? Which order?
10 September 2025 order.
Page 96.
Yes. What you are showing?
Please see.
This was their first writ petition. No.
This is the writ petition from which the appeal arises.
All right. Yes.
This is the writ petition.
Yes. What do you want?
Respondent number 8, it is admitted by the respondent number 8. Respondent number 8 is apparently the PNB, and there is no hindrance committed in the portion of the business of the petitioner.
There is no.
There is hindrance.
It is admitted by the respondent number 9 that there is hindrance committed in the portion of the business of the petitioner. Having heard the submissions, as also taking into account the contentions advanced by the respondent number 8 and respondent number 9, I direct the police would ensure the business of the petitioner in any manner is not impeded and or hindered. State would like to file a fresh report on the next date, so fixed. In the meantime, exchange of affidavits is completed. This order, ultimately, my lord, we had to rush to your lordship's court. Please see the next page, my lord, 24th February 2026 order. That is a fresh writ petition by my learned friend's client. WPA 4020 of 2026. 24th February 2026. Now,
This DRT.
this entire proceedings is an offshoot of the DRT. What he has not disclosed to your lordship, they have a substantive application in the DRT also.
Page 175. I have annexed this.
Substantive application.
Why you are saying that I have not annexed? Suppression. Page 175.
Have I said suppression? I have said you have not urged.
That is not a subject matter.
Now, please see.
Page 175.
The petitioners are aggrieved by the steps taken by the secured creditor to recover the loan. Stand of the writ petition is that they have never taken any loan from the petitioner. Property of the petitioner has never been mortgaged, according to the petitioners. And then, my lord, Can 2. Kindly see Can 2 order, 27 March 2026, from which the previous appeal arose. 27 March 2026. In the writ petition, in Can 2, kindly see the order. It has not been shown to your lordship, subject to correction. Application being Can 2 is taken up. That is a part of the compilation. Kindly see. It's page 41.
Page 190. Page 190.
41 compilation.
Of the compilation. Application being Can 2 is taken up.
I have annexed all the orders.
No, there is no.
Page 192. See.
My lord, I did not disturb Mr. Sahara.
Why you
I
are
do not
saying
want
that I
this
have not
promptitude. I have not said anything.
You have nothing
It's not a
to say.
blame game going on, sir.
You have nothing to say.
Then I go out of court. If I do not have anything to say, I go out of court. But I'll answer, my lord, the Honorable, the Acting Chief Justice.
Outside the court.
Please see, my lord, application. Kindly see Can 2.
Inappropriate.
Kindly see Can 2's order. From this, the appeal arose, my lord. There is a serious dispute, and this is not the first attempt. The whole entire attempt is to get back possession and get control over land which does not belong to him.
Direct to restore the possession.
You have to answer our query.
Yes.
It is not an ego battle. It is a question of the court. You are our officer.
Yes.
He is also our officer. We want to solve the problems. Suppose if today the repair work is done in the backdrop of whatever you are showing, in the backdrop of that, this limited repair is done. And we will protect you that after this limited repair is done, and ultimately in the writ petition it is found that the wall itself cannot stand, having disputed questions or encroaching, we will say that in our order.
And kindly permit me to come back to your lordship on Tuesday. Kindly permits me to come back to your
We
lordship.
have extensively heard Mr. Sharda, learned advocate.
Posing this.
My lord, this is my petition, my lord. I'm being laid by Mr. Bhattacharya, my lord. Probably he's appearing.
This matter,
Represent the Kolkata Municipal Corporation.
this is a very important, the constitutional issue I would like to point out to your lordship before going into the other detail. Kindly turn to page 40. The page 40, if your lordship kindly sees, the order is issued like this: as per direction of higher authority, Kolkata Municipal Corporation.
Page 40.
Page 40, the notice.
The first paragraph. This
No,
is
page 40 of the petition, the public notice.
yes, this is to notify.
And kindly come to the Lord, the person who issues this.
As per direction.
Yes. Now, this is, Lord, governed by the doctrine of dictation, which is ultra vires act of the Supreme Court. The Calcutta Municipal Corporation is the highest body under the statute. There cannot be any higher authority than the Calcutta Municipal Corporation. But on this principle, without going into detail, I would invite my Lord's kind attention to 2004 Volume 2 Supreme Court cases.
Now, just give us 2 minutes. We shall go through the notice.
My lord.
Judge, under the boi, Vidyapati, who have erected setup and stuff. Yes, Mr. Bhattacharya.
Now,
Sure,
my lord,
give us the KMC Act 371 and 500.
yes, I came check now, Your Worship.
Open it out. नहीं है क्या? KMC Act. He is better equipped. But it is your case.
The 371 is a provision, my lord, which prohibits.
Yeah, one more. $371, yes.
But 371 has no application in the instant case because they are not the hawkers. So then kindly come to the 516.
No question is in the function.
This is prohibition of nuisance. I am not troubling my lord with the detail. These also will not certain will restrictions, nothing else. Nobody is empowered to take any action under these two provisions. Then 517A, Lordship may look into it. Though it is not mentioned, that is the power. 517A. Notwithstanding anything contained in section 517, if the mayor in council is of the opinion that immediate removal of any nuisance continuing on any land or building in contravention provisions of this act is necessary, it may, for reasons to be recorded in writing, cause such nuisance to be removed forthwith. Now, my lord, in the present situation, there is no mayor in council. The power is probably vested with the municipal commissioner.
No,
The
please,
municipal commissioner is the highest authority.
Mr.
He acts.
Mr. Bhattacharya, you showed us the restrictions which involves Roman 5 without
Yes.
proper authority affix upon any building, monument, wall, fence without proper authority deface or right.
That is something else. This has nothing to do with not the hawkers. Hawkers are not fixing anything on the wall. And they have to then specify that these are the violations which you have committed. But my point is completely different. The person who has issued the notice has no authority and jurisdiction under the law. This is hit by doctrine of dictation. I am covered by Supreme Court judgment. Many judgment, Lordship is well aware.
But then who has issued the notice?
Yes, that's the basic issue. Someone writes as per direction of higher authority.
Unfortunately, my lord, in so far as my lord, the pleadings are concerned, there is not a whisper, my lord, about this particular ground,
It's
my
a
lord.
question of law. Question of law. I can take any
No,
point of
it's
time.
not that. I said that that is why, my lord, I am not ready with, my lord, the
Oh,
immediate
acha,
instruction.
সেটা অন্য কথা।
Had it been there, I would have come back with I would have had the instructions because there is no pleading pertaining to acting under dictation.
But the notice was there, Mr. Bhattacharya.
Notice is there. Notice is there. It must be by the highest authority. At present, my lord, it is the administrator who is running the Kolkata Municipal
Then
Corporation.
what prevented him from issuing the
No, my lord, I'll tell your lordship, my lord, this, my lord,
29 June?
yes, this, my lord, what Mr. Bhattacharya is submitting, but is not, my lord, the correct state of affairs. It is I'll say, my lord, this is a colorable attempt by way of filing this particular public interest litigation by a gentleman who himself is a member of the town vending committee to bring within the ambit all these squatters and encroachers who are occupying by constructing, my lord, structures beneath the flyovers and the bridges.
This is an attempt to bring them also or classify them also as hawkers.
Please inform us whether the squatters have themselves initiated any proceeding.
Or
the aggrieved
But
person.
the policy is, I'll tell you, Lordship, my lord, a lot of this is completely different. What page 41 contains is completely different. Page 41 is about the pavement.
No, then
That is about the footpath. But insofar as this is concerned, but I have a list. It is list of Joint Commissioner. Are a copy though. It is a policy, my lord, to ensure safety and security of human lives, my lord. So, my lord, this is what, my lord, we have
I
received.
understand that, but
Yes,
you are
it is.
removing them on the strength of a notice.
It is a public notice.
No, public notice. It has to be. It cannot be a stamped notice. There has to be an officer. There has to be an exercise of power. There has to be quotation of the paragraphs or relevant provisions.
Right, so far as pages 41, etc. are concerned, that is on a different perspective. These are by, my lord, the executive engineer. These notices have been issued. But insofar as, my lord, this action is concerned, there are two limbs, my lord. First is, my lord, the policy to ensure that, my lord, the bridges and the flyovers within the jurisdiction of Kolkata Municipal Corporation.
Tell us who is the authority who come with that instruction.
Very well, my lord. I'll come back on Monday, my lord, then.
মানডে হবে না
Tuesday?
না 9 তারিখ রাখো 8 তারিখে আমার আরেকটা ম্যাটার ফিক্স আছে
Very good.
When you can come, Mr.
on 9th if your lordship kindly permits me, Lord.
9th. Heard Mr. Bhattacharya, learned senior advocate appearing for the petitioners. Drawing our attention to Mr. Bhattacharya, drawing our attention to a public notice annexed at page 40 of the writ petition. Drawing our attention, Mr. Bhattacharya submits that the notice itself suffers from a jurisdictional error. And from the same and the authority who had issued the said notice had been mentioned, and simply the same has been issued, quote unquote, as per direction of higher authority.
Should be the highest authority of the KMC.
No, as per the higher authority.
Should have been the highest authority KMC, in my understanding. This without instruction. I'll come back with more specific instruction.
We have to ascertain whether you issued or not, because Bhattacharya, Biplodal Bhattacharya, learned additional advocate general. Oh, you are for KMC, na?
For the Kolkata.
Biplodal Bhattacharya, senior advocate, appearing for KMC, prays for an accommodation today to avail necessary instruction. In view thereof, please the matter for further consideration in the daily supplementary list of this quote on 9th. Yes.
My lord, till that time, because one of the notice says that they should remove
pending before your lordship, my lord.
They should remove.
Come back on the 9th.
By 1st of July.
Now, if Mr. Bhattacharya assures, okay, I don't mind.
I think it is pending before your lordship. But let it be heard on the 9th.
Yes, it's good.
Not record that, but
it's a long process, my lord. I'm appearing for the statement. It's a long, my lord. They will have to requisition the police
process, my lord.
So,
Our experience,
it will not happen before
my lord. We served a notice saying that the honorable court will take up the matter on this day. My lord, in the morning they start demolition.
No, my lords are in CC over the issue, my lord.
They have been given time up to 10 July.
No, then the 1st July they were asked.
41. See page 41, my lord.
But for abundant caution, that Mr. Bhattacharya assures,
kindly takes it up on the first on Monday, my lord.
No, we are keeping it on 9th, but you have ensured us.
Deeply obliged.
Officers are present.
If you find any further steps immediately,
Yes, my lord, kindly appreciate, my lord. We are not being given time, my lord. It is our experience in Kalibar station. My lord, the matter was pending. My lord, matter was item number 30. In the morning, 10 a.m., my lord, they came and demolished the entire structures.
So that is the railway.
My lord, that was also a matter where we took leave when the matter was appearing in that matter, my lord. This is our experience with the railway hawkers, my lord. So, my lord, kindly protects, because 41 says ultimatum has been given till 1st of July.
Or can you takes it about Monday, my lord? I insisted for Monday only, my lord. তা আমি বলছি যে
কিছু হলে মেনশন করো না
মেনশন করিস না, আছে তো, বলছে তো হবে না কিছু, কেএমসির অফিসাররাও আছে তো,
অফিসাররা কোর্টে আছে,
ইনস্ট্রাকশনটা নিয়ে আসতে দে।
Now, let us accept the assurance of Mr. Bhattacharya.
Sometimes it becomes risky. Because, under team, we are not recording. We don't want to embarrass you also, but the thing is, we don't know these officers what they will.
My lord, I said that I'll come back on Monday. I was trying to accommodate my lord, senior Mr. Bhattacharya. He insisted for the 9th. I can come back on Monday.
Monday is a holiday.
All right, come back on 9, but see, Mr. Bhattacharya, that nothing is done in
The officers are present here, my lord. Let there be an unwritten assurance, my lord. করবেন না কিছু। একটু একেও জয়েন্ট কমিশনারকেও বলে দিস।
এই পিটিশনটা রেখে দাও।
আজকে করবো আমরা। সাকশন নেব বলে যদি করি। তুমি গড়িয়ার ব্রিজের তলায় দেখবে ফ্লাইওভারের দাবা খেলে ভাষাই বুঝবে না, দাবা খেলে দাবারও তো স্ট্রাকচার কিছু দেখতে হয়।
Oh, I'll come back on whichever day my lords direct me to, my lord. Be it Monday, be it Tuesday.
That is up to, if you say that there will be no demolition, we have no problem.
Nothing is happening as of now, my lord. The officers are present here, my lord. Let that be understood, my lord. Mr. Bhattacharya never insisted for this interim order, but
Well,
I
subject
think, my lord, it is
subject
the
to what
youthful
Mr.
exuberance, my lord, of
All
Mr.
right,
Bansal.
No.
It is for, as you are appearing, you have you are a responsible
Yes.
person. 9.
Great.
So item number 9, on behalf of the petitioner, I'm appearing being led by Senior Advocate Vikas Ranjan Bhattacharya. He's appearing virtually.
In item 9, my lord, kindly come to order 16th September passed by this court.
কি ছিল কবে কেন চিশ
My lord, para 6 of this order is very important.
Yes.
Now, my lord, takes up my application. The total disregard, my lord, they have again started, my lord, the process. Page 9 of the petition.
Now, paragraph 6, you told us.
Yes, paragraph 6 of the order, where
Yes,
it is categorically stated. May I read out for your lordship? Learned Counsel for the state submits that the KMC, its municipal committee, August, by placing reliance on the first paragraph, which reads thus, quote, as desired by the higher authority, vagabonds from following locations in KMC area have to be removed and rehabilitated in the nearest urban shelter for ensuring public safety and simultaneously providing support to vulnerable individuals. The joint anti-encroachment drives for removal of the vagabonds will be carried out thrice a month, so and so, so and so, so and so. It is submitted that persons residing can be removed only when rehabilitation arrangement is made. Accordingly, this court will not found that at that stage there is no scope need for passing interim order. And now, my lord, they have come up with this notice.
No, but paragraph 7, whose statement is this? It is submitted.
This is for the state, Learned Counsel for the state. He had quoted from the letter of the municipal commissioner. Kindly read 6 and 7, my lord, position will be clear.
Yes, now what has happened?
Now, will that kindly come to my application? Since the court granted me liberty, I had moved an application. Again, Millard, page 9, the notice.
Page 9 of the CAN application, Lordship.
Can.
Application for appropriate orders.
Page 9.
Yes.
9,
CAN
public
1.
notice. Again, a vague and omnibus notice.
Petition.
But there has been no alternative
Nothing.
rehabilitation.
Nothing.
Yes, sir.
I am appealing for the KMC matter, led by Mr. Nirupal Chatterjee. I filed the affidavit of opposition today upon service of the other sides. We have filed a document in the last only annexed in the affidavit.
Affidavit opposition দিয়েছো তাই তো আমাদের দেখতে হয়
It was served back, your lordship, but after that this development is a recent one, few days back. Affidavit opposition had prior to the previous one last year when the PIL was taken up at the first time.
Copy of the application for appropriate order only just now have been served, not earlier. We have initiated the proceeding on the basis of a
Lordship,
letter.
KMC was served yesterday, but the state could not be served because the GP office was not open after.
This was supplementary on 17th February. What
Yes.
is we doing for 4 months?
No, this is a recent development, your lordship. This
The notice is of 27th June.
Can one
Even any reply to this?
not yet, your
Nothing.
lordship. But this notice, this recent.
Petition was filed in February 2026.
Yes, your lordship, we did not file any reply to it, but that opposition is not connected with the present notice which is given by them. This is a fresh notice which is in violation of the first order of your honorable court.
Yes, what you are showing us, rehabilitation of
Page 8 of the affidavit of opposition.
This was before the court when the court heard the matter.
Yes, madam.
So rehabilitation.
No, you have indicated that there are, we have sufficient number of shelters to rehabilitate the
So
applicant.
you show us. Show us that which are the sentence. We will tell them. We will record that.
Page 3 of my report, Mallory, will kindly come to is the report on behalf of the respondent
Page
number
3
2.
of?
The affidavit in opposition on behalf of respondent number 2.
Yes.
Lord, will kindly come to Milord, page 3.
Page 3, yes.
Milord B, Milord, we have stated, Milord, the motion of this eviction was on the basis of the request from the army headquarters. Last paragraph, Milord, will kindly see of this page 3, Milord, that presently the Kolkata Municipal Corporation is operating in 12 shelter houses having total accommodation of 1035 inmates. At present, there exist 285 vacancies at the such shelters. So, Milord, as on date, Milord, there are vacancies. If they are, Milord, at all willing to.
So why didn't you say that, Mr. Chatterjee, when the court asked you?
I was not there, Milord. On the first occasion.
Yes, Justice Paul's order. His Lordship passed this order recording the statement.
Milord, that Milord on that date, Milord, possibly we were not there, Milord.
So then you should have taken instruction after seeing this order. Now you are again issuing another notice. Today the notice, your public notice is 27 June.
এটা তো নয়, ক্যানটায়
You bring instruction, but we will stay this public notice.
Have you seen the notice?
Just now it has been handed up, Milord. I have read, Milord.
Yesterday it was served because absence of.
Give excuses. You are being removed. You should not sleep at night.
Lordship,
Giving excuses.
I am
Why
not
did
giving
you serve
excuses.
upon the state?
Lordship, yesterday we tried our best. The GP office was closed after 12, so we could not serve it.
This statement, my lord, it was not closed, my lord. At 5,
Lordship, yesterday we tried till 5 p.m.
I
Your
remember this.
anxiety. If
Lordship,
it is closed, you should have come and told us that public notice issued. My lord, they are not.
Yesterday I mentioned and your lordship had allowed
Did it
this.
say that you have not? Their notice has not been received.
After that we tried, your lordship.
Don't act smart with the court. Mr. Bhattacharya, learned senior advocate appearing for the petitioner, has drawn our attention to an earlier order passed in this writ petition on 16th of September 2025. In the said order, in the said order, the submission of the learned advocate appearing for the state in the said order,
was submitted on behalf of the state.
State
এইখান থেকে বয়ে যাচ্ছে স্টেট
কোথায় রেকর্ড
দিস স্টেটমেন্ট
কি লিখলে না আগের লাইনটা বলো না
কিছুই শুনিনি এখনো কোর্টে দাঁড়িয়েছে এখনো তো কপি থাকবে
16
এখনো কপি স্যার
wherein the submission made by the learned advocate appearing for the state authorities was recorded. Mr. Bhattacharya appearing for the petitioner submits that on the said date it was submitted on behalf of the state that quote unquote the persons residing can be removed only when rehabilitation arrangement is made. There had been no such without making without making any rehabilitation arrangement. The KMC and public notice has been issued by the KMC on 27 June 2026.
তো উইথড্র হয়ে গেল
27 wherein it has inter alia been observed that the occupiers shall have to remove all the structures within 7 days from the date of the said notice. Stop. Mr. Chatterjee, learned advocate, learned senior, learned AGP.
No, I'm appearing for the KMC.
Mr. Chatterjee, learned advocate appearing for KMC, prays for an accommodation today to avail instruction and the designation of the officer of KMC who had issued the said public notice. Stop. In view thereof, accordingly, list the matter for further consideration in the daily supplementary list of this court on 13th July. There shall be an interim order restraining the respondents from giving effect or further effect to the public notice dated 27 June 2026, annexed at page 9 of the supplement 9 of the application for appropriate orders being Can 1 of 2026 till 15th July or until further orders, whichever is argued.
Let copy be supplied to us.
We remain grateful, my lord.
I'm extremely sorry, your lordship. I'm extremely sorry.
Yes.
But here and now we can receive the copy if supplied, my lord.
I'll supply your lordship.
You supply me.
You give copy.
I'll
Mr. Roy, you also take instructions. Yes, next.
We are grateful, my lord.
Grateful.
Copy नहीं
On instruction,
My lord.
Yes.
In this matter, my lord, the alternate government pleader is changed. Thereafter, my lord, fresh serve may be given, my lord. Otherwise, I served the earlier government pleader. And
We are
now
not-
the new government pleader and new advocate is there. Then you will directly to serve the government pleader.
Mr. Sheikh, can you give a soft copy to Mr.
my lord, not required. We will download it from Satak, my lord. Since it is there uploaded, my lord, why wasting the time of the honorable?
Hard Mr. Sheikh, learned advocate, appearing for
Oh, yeah. Lordship, this is appeal matters. We are beg to appear for the petitioners. The appeal matters relates to the new appointment vacancy has been created in the ration dealer shop. Ration dealer at Hingolganj, not 24 Gurun. That means under the subdivision of Basirat. My lord.
Have you given copies?
Yes, we have the copy.
আচ্ছা আগেরটাতে উপরে লিখে এফিডেভিট অফ সার্ভিস অ্যাজ ফাইল। Yes, what is your grievance?
My lord, matter relates for appointing a dealer of fair price shop, that means the ration shop, to a candidate of the locality for distribution of the food grains to the ration card holders. The area is Hingolganj Ration Card B.Ed College, Bakra Hingolganj block, Basirat in the district of North 20. Kindly comes to page 3. 3 of my petitions. Page 3, paragraph 3. The petitioner state that they came to know that a vacancy has been created for ration dealer at Hingolganj Ration B.Ed College by vacancy number such and such, ID such and such, and for such candidature, many willing persons have registered their applications to be selected as ration dealer, and the district controller food and supply non-20 Parganas issued letter dated 4th September 2005 for interview of selection of food supply dealers against the said official vacancy being 29th November 2024 at noon. That is the interview process. Page 15. Page 15 kindly comes to page 15. Annexure. Annexure P1. 1.5. Annexure P1. The to the Vishwajit Ghosh. Have you got your?
Yes.
Vishwajit Ghosh, Siddiqui Jamandar, Habibullah Satan Sat, 8 names are there. They are all residing outside the area. Outside the area. All. Who?
These persons. Now, whether Jamandar, Mr. Siddiq Jamandar was one of the applicant. Huh?
Yes.
Now you come to your petitioner number 2.
Petitioner number 2.
Huh?
Petitioner number 2.
Who is petitioner number 2?
Petitioner number 2, my lord. They are residing on
Siddiq
the
Jamadar.
With the it is a
Jamadar is the person who participated in the selection process. He was called for a hearing.
my lord, what is going on?
Are, how can you file a public interest?
What is going on now, my lord? They are trying to install a new persons outside the area, 5 kilometers above.
Challenge the read petition. Challenge, ask your Jamadar. This Jamadar.
All the residential flats, all the residential area, my lord, They are applying, my lord.
You
It's a
withdraw
public
this,
interest litigation.
withdraw and file before the writ court. Withdraw and ask Jamadar
My
to
lord, the
prepare an
appointment has already been given on 19th of February.
Huh?
On 9th of February 2025, 6, the appointment has already been given to another person, Srimati Ratna Ghosh.
No complaint.
And there is no complaint. They are serving, and she has qualified, fulfilled all the eligibility criteria.
ফেল করছে বলে আর একজনকে ধরে নিয়েছে
And she is a resident of Basirat subdivision. So, my lord, she cannot, my land friend cannot have any complaint.
Given in the read. You have copied the notification.
ठीक है, रुको नहीं हड़बड़ी क्यों है?
And vacancy has been filled up.
Yes, and or in the month of
you are
February
showing?
2026.
What you are showing?
No, this is the vacancy notification
In which he participated.
in which he participated.
But did the petitioner number 1 participate?
Lord, it appears from the document petition number 2 has participated.
Participated.
Petition number 2
एक
has
मिनट
been.
छोड़ो, देखो 15 नंबर पेज
Petitioner
देखो।
number 1 participated in the selection process?
ওকে ধরে নিয়েছে
Yes.
Yes.
petition number 1 also participated.
No, I don't find
no,
my lord annexure P115 which he has.
Sir,
Deepak Kumar Sarkar, they are the petitioner number 1, my lord.
that is what I am asking. Did he participate also?
No,
This
he is
hearing
not.
was-
He is the complainant of this particular appeal matters, my lord. Complainant, only complainant.
He did not participate.
He made a complaint before the Bosirar police station, Bosirar Food and Supply Department.
Sir, please try to understand. There was a selection process in which you are alleging that there had been illegalities. You are a resident of the village. This is your
Right.
records show that the petitioner number 2 is a person who participated in that selection process. So then we have to dismiss your writ petition saying that no public interest is involved in this. And if we say this, it will go to your prejudice. It is better you withdraw the petition and ask Jamadar to go and challenge it before the writ court.
But my lord.
If entitled to.
But my lord, it has already been
Challenge that.
Challenge
Ask
that if you are
Jamadar to
entitled
get
to.
the name of that person and file an independent writ petition.
Impleading the person concerned who has been given.
Why you are
burdening the
wanting dismissal of your case?
I would tell.
And my lord, would appreciate the person who has been appointed was duly qualified and eligible in terms of.
We are not entering into that.
But in the local area or not, that is only the questions, my lord.
Challenge that.
Suppose somebody has appointed in the 5 kilometers above,
then
how
you
it is
have to
possible?
challenge that.
How it is possible?
Anyway,
how it is possible, my lord? The local
will you withdraw or
withdraw?
Yes. As a Mr. Sadan sir, Lanet advocate,
তাহলে ওই লাইনটা ঢুকলো।
Petitioner. This is the grievance is about the unauthorized construction by an unknown person in the name of a decorator. And it is for the purpose of the warehousing and for storage of inflammable and explosive substances. After complaining, Lordship, the respondent number 8 has issued and pasted a notice on 16/2/2026, and this honorable court has heard this matter on 2nd March 2026, and an order has been passed, Lordship, on the respondents to file a report on 2nd March
2nd March.
2026, Lordship.
2nd March matter was hard.
Yes, an order has been passed here also.
Report was called for.
Yes, Lordship.
Then now what has happened? Have you filed the report?
Millard, two things, Millard. I'll pray for some time, Millard, to come back with the report, Millard. But may I indicate this, Millard? They have alleged that, Millard, illegal construction is made by a decorator near the petitioner's premises. Millard, at this juncture, it was submitted by the petitioner herself that, Millard, a notice has been issued by the KMC under 401 of the KMC Act, Millard, pertaining to that
demolition,
pertaining to that premises number. Millard, I could not, because it had come from the petitioner, Millard, I could not apprise the court of the fact whether the said notice, Millard, is issued to the
Already been submitted.
against the premises in question. Millard, my instructions is, Millard, the premises against whom the petitioner is alleging of, Millard, the notice under 401 has been issued against that very premises.
Very good. You put it on.
I'll put it. I'll put it on affidavit because, Millard, the honorable court on the previous occasion has indicated that if that be so, if it is against this premises itself,
That has been stated in the
right.
Mr.
Yes,
Chatterjee, learned senior advocate, appearing for KMC.
May I, Lordship, Only one indulgence, Lordship. Instead of 30th July, it could be in the 31st of July, Lordship.
Put it on 31st. Yes.
Hello, I am the private respondent number 13 or 17.
So this is the affidavit of service, but served prior to the change of government, my lord.
You are appearing for whom?
Private respondent number 13 to 17.
Private.
Do I have to, may I serve the state after the change of government? It has not been served admittedly. This was done prior.
Right now. If you have the copies, you
No,
can.
it's a voluminous copy. I can serve the soft copy.
You can.
I'll serve in the course of the day then to Mr.
Then we are.
Because there is.
Take a copy, Mr. Mishra.
Yes, my lord.
Your regularization is required.
Yes, my lord. As of now, required from Monday, Tuesday onwards, my lord, because new panel has come up, my lord. I have submitted yesterday only.
Affidavit of service as file be kept on record.
My lord,
I'm for the municipality, lordship.
service is prior to my lord change of regime. My lord, though he is appearing, my lord, main allegation is against the municipality.
Against the
municipality.
This application is not maintainable, lordship.
He is the municipality.
Lordship, I'm for the municipality.
The petitioners are the local residents of Sonarpur Rajpur municipality. They are espousing the cause because the roads are not properly maintained. It is totally broken condition. There is no light in the road, and my lord, the roads are shrouded by herbs and hedges.
Each road.
My lord, kindly come to representation dated 16 January 2026, page 173.
Page 173.
Petitioner address.
Schedule of a land.
Prepare the
representation.
Page 173.
173.
Yes.
Yes, any steps taken by you?
Lordship, this application is maintainable in this for not maintainable in this forum, lordship. And lordship, kindly see lordship 116, lordship, page 116.
Yes.
Yes, 16.
The boundary of the land, lordship. On not partly 10.
Not. Which page?
Lordship,
116.
116, lordship. One of the page of the deed, lordship.
Yes, on the north.
North, lordship, partly by 10 feet wide common passage. Nothing mentioned in that there is a public road. Lordship, this is the common passage.
That is the, well, it is the land purchased by.
No, no.
This is
forget
not the
about
lordship.
right. What about this? You are meaning to say that is a private
Not the public
issue.
road, lordship. That
Not
is
that land is not belonging to you.
no, lordship.
KMC is not involved.
No,
that is
municipality.
my
not.
Point, he is mentioning
but-
the land purchased by.
Sir, will you please let us ascertain? We will give you chance.
Lordship.
We are asking you as regards this allegation of installation of street lights and everything.
Lordship,
did you
this
visit-
road is not belong to municipality, lordship. This is private, lordship. This is not the municipality.
private plot.
Lordship, there is common passage.
Common passage of which premises?
Premises of their premises, lordship.
Sonar Bhumi complex.
Sonar Bhumi complex, lordship.
Approach road from the said complex is to be maintained by the municipality.
No, lordship.
173.
That is easement right. They have got easement right.
No,
That
no.
is.
The
No,
approach
that is not
road
the
from the said
road
complex
of the
is to be
municipality,
maintained by the
lordship.
municipality.
That is not maintained by the municipality.
Out of 81 flats already mutated their names with the office, paying up to date municipal tax. Mutation cases of lot of many have pending disposal for me. It is utter surprise on our part that your authority
So
is.
how it is a public interest litigation?
Lordship, that is the issue, lordship.
These persons are the flat owners in a particular premises.
Yes, my lord.
They are saying that you have not put on street lights. The road is bad, and they are saying in response that that is not our
Only
land.
It has affected us,
So, right.
but also
When it
but
has
also
affected you,
other
no,
persons also.
don't extend. When if it has affected you, you go and lodge a complaint before the municipality. Why public interest litigation?
Well, I have lodged complaint before the municipality.
That as a public interest, you have
Yes.
as a public spirited person.
You have a personal interest.
This is the
In this
personal
you have a
interest.
personal interest because
You have
you
a
admit
personal
that you are a flat owner.
Is a flat owner your own approach road. It cannot be stated to be public.
Withdraw and go before the
We can go before that.
we will give you that liberty.
Yes, yes. We lost coin.
লিখে নাও ওই যে অর্ডারটা
ওই যে অর্ডারটা withdraw, this order shall not prevent.
Grateful, lordship.
Yes, next.
ঠিক আছে।
Item 59 for the petitioner lordship, kindly grant me 1 week accommodation for filing the supplementary affidavit, lordship. Some documents need to be
File what?
supplementary affidavit.
Why supplementary?
Some documents will be need to.
Don't make some omnibus way. What document you want? Coming to court, I will file supplementary. Say adjourn.
Earlier order there is dictated if any supplementary lordship. That's why I'm.
Where earlier order supplementary you did?
Leave is granted to the petitioner to file supplementary affidavit if so advised.
The learned advocate
I'm with the petition, Lordship.
Yes.
This is my affidavit of service.
What is again problem? Same.
Lordship.
Give a copy to him and come back.
I will serve Lordship, but my innocuous prayer is, Lordship, my representation may be considered. That is my innocuous prayer.
Who are you?
I'm one of the resident of that area, being a public spirited person, Lordship, indicating in my representation that the private respondent mutating their name in the record of right of a particular plot of land, which is Waqf property. And in my Waqf deed, Lordship, it is mentioned, indicating that illegal transfer and recording their name in the record of rights, Lordship. I made representation before the concerned respondent.
So whose property is it? They are.
It is a Waqf property, Lordship.
Waqf property.
Waqf property.
Now, who is raising construction?
Lordship,
Mutation, who is
private respondent, Lordship.
Have you served upon it?
Lordship, all are served, Lordship.
Private respondents, they are claiming mutation.
They have already mutated their name in the record of rights, Lordship. In respect of that Waqf.
Whose land it is?
It is the Waqf property.
Or where from we will come?
Lordship, your Lordship will get from page number 14. Page number 14, Lordship.
Have you approached the Waqf board?
Lordship, I made representation also.
Waqf board did not take any action.
No. That is the difficult
Your
situation.
Lordship, I am for the Waqf board.
What is your story?
At the outset, your Lordship, if it is a Waqf estate, it has to be represented by the Mutawalli. The Mutawalli concerned is the manager of the property. So the concept of Waqf is it is a trust. So it is the Waqf property itself is a trust, which is if it is Waqful Aulad or other than Waqful Aulad, it is maintained by a Mutawalli, like the Shibas.
We are not asking that. Somebody has mutated their names in your property.
It has to be looked after by the Mutawalli, or they have to approach the proper forum. That is section 83.
We want to know. We are not the petitioners. We are asking you that if it is your Waqf property, how can it be recorded in the name of private respondents?
They have made a representation before us. They have made.
Who has made?
Now the
I made representation.
Petitioners, they have made a representation before us to take the action. Now, being the Waqf board, Your Lordship, I'll come up with the instruction whether there is any Mutawalli in this concerned property or not. And
then why didn't you take that instruction?
Yes.
It is unnecessary lying for 4 months.
Your Lordship, on the last occasion, none appeared.
Served?
No, on the last occasion, none appeared. So the matter was not taken up, Your Lordship.
When you received a copy of this petition, when?
I received it yesterday. I got an instruction to start just to appear. No, I was asked to appear today, Your Lordship. I've appeared before Your Lordship. So kindly fix it tomorrow or Wednesday, whatsoever. I'll come up with instructions.
Come with that instruction.
Come with the instruction. What step has been taken upon receipt of representation. Okay.
Lordship, let my affidavit of service be kept in record, Lordship.
কবে রাখবে?
এটাও নাকি এমডির সার্কুলার ফেরত দিয়ে দেয়।
ঠিক আছে, সার্কুলার রাখছি।
Grateful.
Grateful.
Come back at
Mark.
না 2 PM আসতে বললো।
এক্সেপশন দিলে না, করেছেন না করেন?
Or 17.
Well, I beg to appear for the private respondent.
Respondent
10.
4.
This is my affidavit in opposition, my lord. I was directly.
Affidavit of opposition, my lord, ki just today, my lord, sir, my lord, ki the, I am only one day accommodation. I will give the reply.
My lord,
next Thursday.
Yes,
my lord, if I may be allowed to say, submit my case or.
We will hear you.
My
এদিকে এসো
No,
এটা এই order
নিয়ে নিন।
লিখে নাও। না না নিয়ে নাও না hard Mr. Dead, movie dead.
I am
Dead who is for the state.
respondent 4.
I am appearing for the state, my lord.
Your state.
Yes, sir.
Very good.
My lord, request that Lord AGP be, he will be appearing, Mr. Ajit Kumar Mishra, along with.
All right.
এটা তাহলে একটু মিস স্যার।
Dead movie day appearing for petitioner and for the petitioner.
Respondent number 4.
Over details to এইদিকে
My lord, item number 18, I beg to appear for the petitioner. My lord, earlier Lord ASB was appearing. This matter is, my lord, regarding some uh, misappropriation of funds in Shah Institute of Nuclear Physics, my lord.
Your Lordship, Mr. Tiwari is appearing on behalf of the union. He's currently in court number 16. If Your Lordship can give us a very short passover.
May I pray for one thing, my lord? Kindly come to my lord, page number 138. What has happened, my lord? Yes, yes, no difficulty.
Lordship,
Any day.
I am appear. Lordship, I am appearing for the Union of India in AD 18. Lordship.
Next Tuesday,
There's a technical problem with my video.
next Thursday. Inform your seniors.
Yes, sir.
Lordship, I am led by the learned ASG in this.
Next matter. Nineteen.
I'm for the petitioner, my lord. I'm praying for a not today.
You will go on praying for it, sir. Make it a habit. You will not appear in time. Again, when the matter will not appear, you will say extremely urgent, waited for such and such.
My lord, my senior is standing before
Yes,
Hotel number 18, my lord.
If I am appearing in person in this matter, Your Lordship, I was directed for the Union of India. Lord. I was directed to file a supplementary affidavit with regard to the UDAN scheme implemented by Ministry of Civil Aviation. Lordship, this is the affidavit কপি একটাই তো আছে আমি দিয়ে দেবো রিপেয়ারিং ফর আর তো হয়েছে
Yes, have you got the scheme?
My lord,
Have you produced the scheme?
yes, Your Lordship, I have served them.
When? Just now?
No, Your Lordship. It was served on 18th of March.
My lord, I found, my lord, my learned junior has received, sometimes back. My lord, may I take instruction and come back, my lord?
He is an outstation advocate.
No, I am a local advocate.
Pardon?
I am a local.
Oh, you are a local.
18th of March, I have served them. Along with Airports Authority of India and Ministry of Civil Aviation.
Mr. Sharma, the petitioner appearing in person, submits that pursuant to you have filed a supplementary affidavit.
Yes, Your Lordship.
Submits that pursuant to an earlier order. The petitioner has. Have you filed scheme
Supplementary affidavit? Yes, Your Lordship.
Pursuant to the earlier order of this court, Mr.
Number 11, my lord.
I'm for the petitioner, my lord. There is a direction, my lord, to file affidavit in opposition by the
9th of March 2026, direction upon the state authorities to file report and liberty to the private respondents to use their affidavit in opposition. But I am filing my opposition, my lord. I have served copy upon my.
You have given reply?
Yes, no.
My lord, within a week, my lord, we will file a reply, my lord.
Affidavit in opposition as filed on behalf of the respondent.
Respondent number 11, my lord.
Your Lordship, I appear for the Union of India. Your
But
Lordship,
I am for the petitioner in this matter.
Yes.
The matter involves me about the Vande Mataram song, which was accepted as national song by the Constituent Assembly, only 2 stanzas. Now the government of India has issued a notification which really violates everything. That impugn notification at page 15.
before my learned senior starts, Your Lordship, there are 2 judgments which we, for Union of India, will like to place. Kindly keep it on Tuesday so that we can place those judgments, one by Karnataka High Court and the other by Supreme Court.
Mr. Bhattacharya, you have used that compilation.
Yes, I compilation did.
The earlier court is for time to
Yes.
file. That has been filed.
It's being handed over today.
You have given a copy.
Yes, yes, yes.
Yes, tell us when.
Your Lordship, Tuesday.
It cannot be done.
তুমি judgment গুলো আমাদের দিয়ে দাও।
Ninth. Your another matter is on 9th. Now,
Ninth.
9th we are keeping.
Your Lordship.
Grateful, madam.
In the meantime, I would expect my learned friend to supply the references so that we can also come ready.
You file that.
Your Lordship.
Really, you can within 9th. You can.
Your Lordship.
একটা কাগজ দিলে না কি একটা compilation.
What have you given? Compilation you have
Yes,
given?
yes, madam.
The record করে দাও।
Oh.
Without
The compilation as filed on behalf of the petitioner is taken on record. আচ্ছা,
My lord, requesting for a short passover. My senior is he's on his leave on court number 34.
2 weeks. Yes, next.
May I please, Your Lordship? Lordship, kindly come. Order dated 20th April 2026. There was direction for filing affidavits. So, affidavit has not been filed as
State.
by state and Union of India both.
Which for Union of India?
On the last occasion, Union of India appeared. এখন তো নামটা Lordship, kindly peruse 20th April order, Lordship. There is written.
As no one appears on behalf of the, লিখুন। As no one appears on
Milind Mohan Ghosh. Is your other side? Is your other side?
Learned Advocate General Milord is appearing. On the last occasions, Milord, we served Milord the copy of the petitions, Milord, on the same day. And the additional Advocate General is also appearing.
You are there?
No, my lord, I'm not there, my lord.
Was it heard by the previous bench?
Yes, Milord. No. This is for the first time. On the last occasions, just Milord, I opened the case, Milord. Then it was fixed because the urgency is involved.
Where is the Advocate General?
May I call Mr. Advocate General, Learned Advocate General? May I inform, my lord? Short password, my lord.
What happened, Milord, that these notifications, Milord,
meantime,
which
there
was,
will be 4 days.
Milord.
Friday, Saturday, Sunday,
Friday, tomorrow, Milord, tomorrow.
In the meantime, there will be 4 days.
Milord, tomorrow, Milord. Tomorrow, Milord.
Tomorrow, till we take up original side matters, Mr. Thomas. It will be in the list if you want.
And Milord, in the meantime, because what happened, Milord? But by this time, pursuant to the notifications, many students, Milords, that sat in the examinations, or someone, Milord, some groups, Milords, they are, Milord, going to appear before those examinations.
My lord, I have just spoke, my lord. The GP just asked me to appear, my lord, for the state, my lord. For the state.
Advocate General.
My lord, the government pleader, my lord. My lord, I believe, my lord, in this matter, it's because of the issues concerned. The learned.
We are wanting, have you taken instruction, got the copy, everything done?
We have not got the copy.
My lord, right now, my lord,
on that date itself, it was given.
Yes, Milord.
He must have
pursuant to Lord's directions, we served, Milord.
So what is happening in
I understand.
And both, Milord, additional Advocate General was there. And Advocate General.
I understand, my lord. My lord, this, my lord, issues are getting resolved, my lord, one way or another.
This we are hearing for the last 3 days.
I understand, my lord. I understand.
Sir, think about the advocates of the petitioners.
Lord, I will speak to them, my lord.
Double payment they are making.
Yes.
Once I am new person, give me another copy.
No, my lord, so my lord, I will
While
speak.
you're
my lord,
responsible
my lord, they-
persons, why don't you take a decision? What is stopping you from taking a decision? We are, you are a brother, please come, take the issue. Simply testing the patience of
I, my lord, I will speak to them, my lord, right away.
not today করে রাখ
আমি কথা বলে নিচ্ছি একবার জিজ্ঞেস
yes next
ইস্যুটা খুব সিরিয়াস
you be here tomorrow, ask the advocate general to be here
Because
so that
of
he is insisting for
Yes.
an interim order.
Yes,
Let us
yes,
consider and
because
allow it or
yes,
discuss.
the issues concerned, my lord, I believe, my lord, London.
Yes, next matter.
Grateful, my lord.
আমরা তো এইদিকে
And 26 when I appeared for the review, it has been listed but without serving any notice to us.
we have not listed it.
After a long time, and the matter has today appeared.
My judge, we have not listed, my lord, at least.
Yes, yes, we have
Have
got
we
it from
listed?
the combined.
Oh, mention, sir, mention. তো notice দিয়ে mention করছি। তো বললেন তো, he was present, my lord. তো notice দিয়ে বলছি যখন
This matter was, বলুন ম্যাটারটা হার্ড হয়েছে অনেকবার ওখানে স্যার লড়েছেন ম্যাটারটা পুরো সব নাম্বার 4 হার্ড দি ম্যাটার প্রিভিয়াস কোর্ট
কি হয়েছে?
কাইন্ডলি অ্যাকোমোডেট ফর দিস মানে আমাদের বলতে দিন আমাদের 1 ঘন্টা
My lord, may I tell you,
এভরিথিং ইজ রেডি
my lord, may I start today? So that
Tuesday. Yes, next.
He may start, I have no objection.
Give the copy to him. You take whatever we hear it on Tuesday. Yes, next. 27.
মামলা করা যাচ্ছে না।
For the petition.
Oh.
The presence of my lord, the respondent is required. Because to these applications, my lord, the matter has not come at our instance. In due course, it has appeared. For the first time, as hearing the matter is appearing, we have prepared our paper book.
Have you filed paper books?
paper book is here, my lord.
দুটো set লাগবে।
দুটো set আছে, দুটো set।
Respondent number, who is respondent number 1?
Union of India. Union of India. Yes, Mr. Probir Pomik.
He's appearing.
Mr. Probir Pomik. They're appearing for Union of India.
Along with Mr. Somrat Goswami is recorded in
Yeah,
order
yeah.
number
Last August.
31st of October 2025.
The paper book as filed on behalf of the petitioner
Lordship, my appeal, I was praying for not today only, if it could be taken up on Tuesday.
Monthly list, yes,
Your Lordship, Tuesday.
yes, next.
Monthly list, July monthly list.
Much of.
But I am appearing for the respondents. I could not serve reply, my lord, the copy just now, my lord. Next day.
Monthly list July, in the meantime, you exchange your affidavits?
Just now, my lord. Just now, my lord. Today I have received the reply. Just now, my lord, I have. Yes.
So, monthly list of July.
May return his position.
Please bole do.
May I be permitted to file affidavit in opposition, my lord? May I file it?
Affidavits as filed by the police are taken on record. Ardal advocate appealing for the respective party is the
My lord, I am for the petitioner, my lord.
Who is opposing him?
My lord, the dispute in between the, my lord, the two,
Who is opposing him?
my lord, the,
Against the state or private individual?
my lord, I am for the BSNL, and my lord, the two private respondents are also there, my lord. And my lord, kindly see the last order, my lord.
Who is the petitioner? Lead petitioner?
I am for the petitioner.
Original applicant?
Applicant is one of the wife. One of the wife, my lord, was the applicant. My lord, it is
Any
the
advocate represented?
yes, yes, yes.
Who is that?
My lord, before this honorable court also, last 3-4 days matter was heard.
Who is the advocate? Next Thursday. Yes. Intimate to him. Intimate to him next Thursday. Yes. 31.
My lord, one Subhajyoti Ghosh, my lord.
He sent him a notice.
And my lord, what I am praying, my lord, there was the proceeding was initiated before the tribunal, and the last occasion, this honorable division bench was pleased to direct to stay all further proceedings of the tribunal. And my lord, there was also direction if the learned advocate of the petitioner will not contest the matter, in that case, my lord, matter will hurt. So, my lord, that interim order may be extended. Kindly see the last order, my lord.
They filed to law. It is expiring when? It is expiring.
Yes, my lord, because my lord, if
It has already expired.
What is the interim order? On last occasion, direction was given upon the tribunal not to take any coercive
yes,
steps
ma'am.
against the department. Then it is recorded that the interim order will not continue. Oh, this interim order is the department. আচ্ছা আর মিস্টার ঘোষ লার্নেট অ্যাডভোকেট অ্যাপিলিং ফর দ্য
I am for the respondent, my lord. My lord, this matter was taken up, my lord, several occasions, my lord. But my lord, they are avoiding, my lord, they are appearing, my lord.
No, they were not avoiding. They were here yesterday when you were not there.
But I was here, my lord.
You were not there.
Your lordship, can you see?
Yesterday when it was called on, you came later, no?
That is another matter, but this is my lord.
Not this matter.
No, this matter. That matter has been fixed, my lord, on Thursday, that matter.
When did we fix it?
My lord, I am for the petitioner led by Mr. Othurup Banerjee, my lord. My lord, he has not come to the court, my lord. I pray for time in these two matters, 31 and 32. I am led by him, my lord.
Next Thursday.
Next
Grateful.
Thursday, my lord, because there are similar matter, my lord, will
Did
appear.
it appear next Thursday?
Next Thursday, on Thursday, my lord.
Yes, call it.
Grateful.
Milord, this is Milord. Kindly recall, Milord.
Yes, give us the papers.
Yes, Milord. We are seeking the benefit of the order, Milord, passed by the Honorable Supreme Court with regard to Milord. Kindly.
Mr. Das.
Milord, my junior informed him yesterday also.
This is the problem, na? Yesterday we saw him waiting. Today again he is not. You are there, na? Take it out. Find the law. Yes. Tell us what is the matter.
No. He is not there.
Then we are releasing the part.
No, Milord. Please, Milord, kindly, Milord.
Please,
Milord, this is tribunal application.
Yes, you place your case.
This is your lordship has the determination. Your lordships have the
Paper book, paper not there.
No.
Paper book not
No,
there.
no.
Then you will be arguing from which paper?
No, this is the writ petition, only opposition reply.
You are ready?
Yes, Milord. I will do this. Milord.
Yes, unnecessary part.
Yes. Milord.
You are appearing in which matter, Mr. Rohit?
I'm 35 million only. I'm not answering as respondent number Union of India only. 35.
35 we have not called.
No, একসঙ্গে with 35 you are for Union of India.
Then who is the advocate Who is the advocate representing those applicants?
Original application.
Mr. Himanshu Datta. 3435 Mr. Himanshu Datta for the applicant. And Mr.
Not Das.
Dash. B.R. Dash, Mr. B.R. Dash.
Yes, has he come?
I have not seen him, Milord. Yesterday, Milord.
Let us understand, yes, what
Milord, here, Milord, whether a particular disciplinary proceeding against an employee, Milord, whether it should be guided by 2006 rule or before that, Milord, if the offence committed, Milord, prior to that in proportion of the rule. Here, Milord, the case is, Milord, your lordship is considering, Milord,
that Supreme Court decided the issue.
They ordered আগের দিন জজকে দেওয়া আছে, একটু বার করে দিন না।
Date of the
Supreme Court order, Milord, that is, Milord, date 26 September 2025. My lord, got it? My lords, এই জজকে দিন না, লুজ কাগজ ছিল, লুজ কাগজ। 26/9/2025 অর্ডারটা দেখুন।
এই সুপ্রিম কোর্টের অর্ডারটা চাইছি।
26/9/2025 আগের দিন দিয়েছি।
26/9 এটা একটা কপি আমি দেখি।
এইটা এই দুটো এইটা এইটা কি
না
এটা 6
the order of the Honorable Supreme Court dated 26
yes এই দুটো দেখুন তো, এই দুটো কিনা না এই দুটোই 6 আর
We have a copy here.
yes আচ্ছা মিলট মে আই রিড
No, no, let us go.
আচ্ছা good. এটা applicable নয় applicable for error না and we find something there
You have only one copy?
which one Miller? No, I have given 2 copies Miller on the last page.
2 copies. Your junior took back.
Took back?
No, you keep it. You
No,
keep
no,
it.
no, 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 Miller, kind. No, no, it doesn't look nice, Miller. Kind.
No, you keep.
No, 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 Miller,
You
kind.
place it. You keep.
No, no, now, no.
না না নীল না আরে নিতে কি অসুবিধা আছে বার করে দিতে
ওদের
দেখো এখানে
this one that is not a one data করে
yes, Mr. Vasu.
yes so Miller this short point Miller that has fallen
The court has decided that.
the court has decided there are 2 parts Miller in respect of this gentleman Miller the court has directed to condone Miller the amount, my lord, which stands to the tune of rupees 1 lakh or like that, single amount, the court says condone it. But the moot question, my lord, that falls for consideration before the Supreme Court and as well as your lordships, my lord.
So what happened to the charge sheet then? It was quashed.
The court 142 exercise and quash, because here, my lord, in
No,
this,
no.
but in this, no.
As regards application is not 142. That is 141.
Well, that is 141 with regard to 2006 applicability.
So the charge sheet issued under the new rules were set aside, saying that the 1968 rules will be applicable.
Right. No.
High Court
2006 rule will be applicable because 58 says
was charge sheet was issued under the 1968 rules or 2006 rules.
2006 rules, my lord, charge sheet was issued.
Very good. Now the Supreme Court says. Now what did the High Court say?
My lord, the High Court said, my lord, before the Honorable Tribunal, that is, my lord, WPC 38 of 2082. The judgment dated, my lord.
High Court said 65 rules will be applicable.
CCS rules applicable.
65 rules.
Yes.
So that has now been turned around by the Supreme Court saying that no, it will be 2006.
So yes, the point is no more recent trigger, my lord.
So then what happens to the charge sheet in respect of that person?
That gentleman, my lord, it says, my lord, it was under the convention.
No, there is no mention.
No mention.
What will happen to the charge sheet and the discipline? So it has abandoned because
Because, my lord, the Supreme Court had said, my lord, that we have been informed that respondent number 1 has superannuated, and the allegation against him was that some bills were passed which were not genuine for an amount. Supreme Court last sentence, my lord, thus as far as equitus shall be given to the entire controversy.
So
that means nothing to be done.
In respect of the original applicants in these three matters.
In these three matters, my lord, your lordships were kind enough.
Maniklal Kaur. One is Maniklal Kaur.
And Ratan Krishna Pal. Ratan Krishna Pal and Maniklal.
Another is Ratan Krishna Pal and another is Subroto Gangopadhyay. These are the persons.
Manik, Miller, Manik, Ratan Krishna, Tapan, Subroto.
Mr. Banerjee, please take your seat. Let him argue. Yes.
Miller, kindly seize the chart. Your lordships directed that I have to take instruction as to why, my lord, the same benefit with regard to the last portion of
your... We are coming to that. As we understood your point. We are wanting to know that in respect of the these persons here, they have also superannuated.
Yes, my lord, that is my instruction. Yes.
So they have now they have you have not disbursed them the pensionary benefit.
Because, my lord, the CBI has framed them, my lord, trial is on, my lord. The trial before the and CCS rule, my lord, also creates a bar.
No, let us first understand that they are in respect of them also the charges does not survive.
Because no, my lord, in
view of this order.
In view of this order, my lord, in that case,
was it a single separate disciplinary proceedings?
Absolutely.
The charge sheet was same date.
No, different date. 2007 is the date of commencement of this development.
Let us understand. Then the proceeding against them does not is no longer survive in view of this order.
In respect of this gentleman, my lord, this gentleman.
In respect of this gentleman, you are saying that 142 was exercised as regards the arrears and the disputed amount.
Right.
Court said that in these peculiar facts, whatever you have given to the respondent number 1, you will not take it back.
Right.
This is
now, my lord,
the facts of this case.
This is fact of the case.
But the main issue as regards survival of the disciplinary proceedings, that issue is no longer there.
That by reason of the division bench order, my lord, the order under appeal before your lordship, the my lord, it categorically says that invocation of Rule 2006 is absolutely, my lord, without jurisdiction, and that is why court interfered. Let us place the order, my lord. The order that was.
Please, Mr. Vasu, our queries are there. Please answer our.
Your lordship says that the departmental proceeding. What is the fate of that?
What has been the fate? What has been the fate after this judgment? Whether you can re-argue that those proceedings should...
Yes, I can re-argue because I have said, my lord, this chart indicates, my lord, the chart I have just handed over, that what are the fundamental difference between the gentleman, my lord, who went to the Supreme Court and the petitioners.
We are saying all the gentlemen were issued charge sheet,
right,
applying the provisions of this
2006.
2006.
Correct.
High Court said All right decision, 2006. Supreme Court said that it will be 60 high courts, right?
No. High Court said that you cannot invoke 2006.
High Court said 65. Supreme Court has clarified saying it should be 2000.
Correct.
So the charges do not survive. Proceeding goes. Now you argue on this point. You tell us whether if those persons have been superannuated, how much money has been given to them in respect of those persons, and then you argue that don't direct us to give back that not to take back that money from them.
No, first of all, yes, my lord.
No, am I clear?
No, my lord, yes, my lord, but the answer is, my lord, subject to correction, my lord, that if your lordship, my lord, your lordship feel, my lord, that our case, there are fundamental difference between the two factual metrics of these two cases.
Then you will be at liberty to take back the money which you have already paid. That
Yes,
is the
not
full
only that,
liberty.
no, because I did not release, my lord, the full pensionary benefit because of this case, my lord, the pendency of the criminal case. Mr. Dash had argued that withholding of their retirement benefits on account of the pendency of the criminal case, my lord, is contrary to law. In this case, my lord, which is your lordship's and Supreme Court's order, in that case, my lord, there was no criminal proceeding, my lord, filed by the CBI. He was not entangled with the criminal charges. In these cases, my lord, the severe criminal charges are there. And my lord, the departmental proceedings are also there.
Of others,
I said, my lord, the first departmental proceeding, your lordship's query was exonerated. Second departmental proceeding was not completed. Honorable Cat quashed the charge sheet.
not so far. Ratan Krishna Pal. Proceedings
Ratan, yes, yes.
You take that tabular form given to us.
Yes.
Ratan Krishna Pal.
Departmental proceeding was completed before retirement, but CBI case is still pending. Ratan.
Oh. TP completed before.
Yes.
Before retirement.
Yes. Second.
But you have not paid any.
Yes.
You have not paid any retirement benefit. What was the punishment?
Provident fund and provisional pension.
You have withheld.
No, paid.
Paid.
Where do we find that? In your chart?
No, in my chart, my lord, I was only demonstrating, my lord, the fundamental.
Retirement benefits, pension, provisional pension, আর গ্র্যাচুইটিটা মিথুল করে রেখে
ও এই কথায় আরো আছে আচ্ছা 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 পেনশন প্রভিশনের গ্র্যাচুইটি হইতে পেনশন প্রভিশনের গ্র্যাচুইটি আর তপন দাসের সব পেড করে দিয়েছে আর আর ইন রেসপেক্ট অফ আদার পেনশন প্রভিশন এত আচ্ছা সো DP completed, retired, DP completed.
In respect of every person, DP has been completed.
Milord, I will come one after another, Milord. So far as Maniklal Kaur, charge sheet issued, charge sheet quashed.
Charge sheet quashed by whom? by High Court.
by tribunal. Honorable High Court, Honorable Cat quashed the charge sheet.
Where are you reading?
The last page, my lord, or the chart I have handed over. The second column, first page, my lord, it starts from Director HR BSNL versus Maniklal Kaur. CBI case
In
pending.
respect of Ratan Krishna Pal, you have completed the DP.
Right.
And punishment order imposed.
Imposed.
What was the punishment?
What was the punishment?
Taking into the account of the page 78 of the writ petition, entire records of the case and on objective assessment of the facts and circumstances, on obtaining the necessary approval, the authority ICC KK Sapra, Chief General Manager, Calcutta Telephone Disciplinary Authority, in exercise of powers conferred upon me by BSNL, CDA rules hereby order that the pay of Ratan Krishna Pal be reduced by one stage in the time scale of pay 20,600 to 40 such and such for 1 year with immediate effect. It is further ordered Ratan Krishna Pal will not earn increment of pay during period of such reduction, and on expiry of the period, the reduction will have the effect of postponing the future increments of his pay.
Right. So against this tribunal order, High Court, they went to High Court. High Court said that you have proceeded under wrong rules. It should be under 6 years. Supreme Court says that no, proceeding done by BSNL is right, because that has been done under 2006 and 2000 is applicable. This is the chapter. So please tell us, Mr. Basu, in respect of Ratan Krishna, Maniklal, Tapan Das and Subroto Gangopadhyay, what had been the punishments imposed about? Then the punishments becomes workable due to this order. The manner in which you conducted the proceeding, charges were established, you imposed a punishment. Supreme Court has upheld that.
Yes.
Yes. We will hear him that what order it is. Now, what further grievance you have now?
No,
If the disciplinary punishment order survives after the Supreme Court order, now what can be the further? You will deduct the punishment and hand over the remaining. This is the only thing.
Yes,
there you are bringing an issue that there is a CBI case pending for which we only to cut short the litigation. We want to know from you. Suppose in respect of Ratanlal, there was 3 increments were stopped. Maybe now nobody were dismissed. Anybody was dismissed?
No.
So it is a quantum of punishment which you have imposed.
Yes. Now, my lord, your lordship's query, my lord, if I am to answer, the first of all, my lord.
No, then what we are wanting is, Mr. Vasu, today you please take instruction and tell us, are you prepared to pay them the benefits after deducting the punishment which has been issued? Suppose punishment, there are the 3 increments cumulative effect, maybe you don't like that. So
what remains further? What remains further after the conclusion of the disciplinary proceedings? If I have resorted to 2006 rule, if the courts do not disturb the findings as per the Supreme Court, then the matter ends. Yes, it comes to a logical end. That you allow him to retire. Now you pay the remaining amount. Now what is the bar?
What is the remaining?
The bar is, my lord, I argued, my lord, that CCS Pension Rule 1972, my lord, in this type of circumstances, which is not in your lordship's hand.
Please
My lord,
give us
what
the
does the law
rules.
say?
Please give us the rules. No, Mr. Das, what had been the punishment imposed upon him?
My case is now very simple, my lord, as far as Maniklal Kaur is concerned.
You are appearing for Maniklal only.
I am only Maniklal.
If Maniklal is there, my lord, I was addressing on Ratan Krishna. Maniklal, my lord, the proceedings should squash, charge sheet. So I have to start.
Yes.
In this,
he is Maniklal.
Although
he said initially that he be presented both.
ক্যাট কস করলো, হাইকোর্ট বললো যে না এটাতে 2006 রুলসই অ্যাপ্লাই হবে, সেই জন্য কোয়াশিং সেই জন্য ট্রাইব্যুনালের অর্ডারটা তাহলে proceedings are
সেটাই তো বলছি, হ্যাঁ ওটা দে।
এবার হাইকোর্ট বললো না, হাইকোর্ট
ওটা কি
বললো
বলছে তো?
1965 এ করবে, এবার সুপ্রিম কোর্ট বলে দিল 2006 এ করবে। তাহলে 2006 এ করে থাকলে পানিশমেন্টটা ইজ ভ্যালিড হয়ে গেল।
ওদের অরিজিনাল
Valid হয়ে গেল। What is the punishment given in that case?
সেটা আমরা পারবো আপনাকে।
আমাদের তো আগে এটা করে তারপর ওই আর্গুমেন্টের
আসলে ওইটা ফাইল করেছিল কবে?
Mr. Basu, for our convenience, we are wanting Ratan Krishna Pal. You said that the DP has been completed.
Punishment
Has
imposed.
been imposed.
Imposed.
So in this Ratan Krishna, I want from you, we want this instruction that what will be the fate of Ratan Krishna or not, whether you will release the benefits.
Yes.
After deducting the, if that is so.
That has been done. We complied with everything.
Oh, that has been done.
Now, Millard, the order has been, Millard, that the order, punishment order, Millard, that has been done. Now, Millard, today, your lordship's query, what remains then? Now, my answer would be that since Ratan Lal has been implicated in a CBI case, whether the law creates any impediment in releasing, Millard, the benefits, other benefits attached to his service. That is what I argued, Millard, before when your lordships used to sit, Millard.
Now, who is for Maniklal? Maniklal is not.
Who is Maniklal?
Milord,
You are Maniklal.
In the change context, Maniklal becomes separate, Milord, now.
No.
Because Maniklal, in Maniklal's case, only the gratuity is withheld. And gratuity is withheld under Rule 69 1C of the CCS Pension Rule 1972. The Honorable Supreme Court, while giving a quietus to the controversy, because the controversy is dating back to years, even decades. So they gave a quietus to the controversy.
Mr. Das, that observation of giving quietus shows that in the facts of the case, Supreme Court exercised 142. The ends of justice.
My
Basu says that this analogy will not apply in respect of Maniklal because we have withheld his gratuity since he is involved in a CBI proceeding. And now he wants to argue that let the court decide that whether it becomes a new cause of action. Your proceeding has attained finality. Punishment imposed. You suffered the punishment.
Sorry, I'm sorry for the
interruption. He is not right.
No,
he is not right.
No, Millard, he is consciously because making the submission. I said, Millard, I was confined to the submission and the court's query with regard to Ratan Lal. I was addressing my lordship on Ratan Lal.
That is the thing.
Now, Maniklal,
Maniklal, what has happened?
Maniklal, what happened? Charta দেখুন charta to just
Milord, Maniklal, I am saying it.
No, I am saying first departmental proceeding was exonerated. Second departmental proceeding was not completed.
That is the main thing.
Go a bit slow. We are
Sorry, Millard.
Exonerated. That is the main thing.
We are not
Sorry, no,
done as per.
No, Millard. Sorry, Millard, I apologize. First departmental proceeding was exonerated. Second departmental proceeding was not completed, but the Honorable CAT Tribunal quashed the charge sheet. A CBI case is still pending.
Not started him.
So I want to start.
Not started him.
Yeah, how could I? I challenge this order before I challenge this order before the High Court.
You want to reopen the issue?
Yes. If the because yes. No, because we.
And
trial is going on.
Quash the charge sheet, you issued. ওটা পেন্ডিং আছে।
That's why for this court case inquiry held up. Now, Mr. Basu, what is this CBI charge sheet issue? CBI has issued charge sheet.
Trial is going on.
Who is
Against him
in the criminal case?
Yes. And our charge sheet departmental proceedings took quashed. gone. And High Court said, my lord, that the
You are now taking the ground that since that CBI proceeding is pending, I will not disburse the benefits to
I
you.
have to full swear that by reason of the High Court's order affirming the Honorable Tribunal's view with regard to the applicability of 2006 rules,
High Court, Supreme Court said.
High Court also said, my lord, I am before your lordship challenging, my lord, High Honorable Tribunal in Maniklal's case relied on, my lord, division bench judgment presided over by Justice Tandon. Now the benefit was given to them, my lord, that yes, to invocation of Rule 2006 with regard to a misconduct alleged to have occurred, my lord, prior to the pronouncement of this rule. Now, my lord, we lost on that score. And accordingly, my lord, as a sequel thereto, my lord, the Honorable Tribunal was pleased to set aside the charge sheet. I came before your lordship, which is before your lordship, Justice.
Your charge sheet or CBI charge sheet?
My charge sheet, departmental charge sheet. CBI charge sheet has not been questioned or possibly. Departmental proceeding charge sheet. CBI proceeding is continuing. The same was initiated before his retirement. That is the law. Disciplinary proceeding is instituted while the employee was in service, whether before his retirement or during re-employment, shall after the retirement of the employee be deemed to be a proceeding under these rules and shall be continued and concluded by the authority by
That
which
is regarding continuation of the proceedings, whether you have the power to continue the proceedings even after retirement.
Yes, the answer
But
is
regarding payment,
Mr. Basu, your proceeding is no longer there. If we have understood your argument,
yes,
that now today we cannot, though this has been the development, High Court order has been set aside, Supreme Court has said this, question of revival of your proceeding will not arise. That is stopped, closed chapter.
No.
Now you
No,
have to
Millard,
show us.
no, Millard, kindly, give me 2 minutes. Millard, in so far as Ratan Lal, I come one after another. Ratan Lal charge sheeted, disciplinary proceeding concluded. Up to that clear? Punishment was imposed.
What was the punishment?
The punishment I read, Millard, that
3 increments.
That was complied. Now, Millard, during the subsistence of the departmental proceedings, CBI, Millard, lodged FIR, charge sheeted, criminal proceeding continued.
In respect of
Ratan. না রতনটা আমি রতন দিছি ক্লাস মিনিট কাইন্ডলি ফার্স্ট টেক রতন
Ratan does not say that.
Huh?
In your Ratan, CBI inquiry we do not find.
CBI?
The note which you have said, why posted as a
Departmental proceeding was completed before, but CBI case is still pending in Ratan, I'm saying.
Separate things. One is the disciplinary proceeding, another is a criminal CBI proceeding.
Right. I am talking about both. This departmental proceeding was concluded, punishment imposed. During the subsistence of the CBI departmental proceeding, CBI had also filed a charge sheet. Trial is going on, yet to be concluded. Departmental proceeding concluded with imposition of certain withholding of increment that your lordship has seen.
That has now attained
Finality. Now the question is, so far as Ratan Lal is concerned, that why I can't release the other benefits attached to his post. Ratan Lal.
Yes.
My answer is, Millard, that CCS rules 1972, Millard, says, it speaks about the consequence.
Let us take her one by one.
Yes.
Yes.
এই বইটা পাওয়া
Under what provision?
I am stopping, Millard, Central Civil Service Rules, Millard, Pension Rules 1968. এটা বই হবে
1972.
1972.
72.
Rule 68, sub rule 2, 69. Provisional pension. এই দর্শককে দিন না ততক্ষণ দিন।
No, then you will not be able to place.
Rule 69, provisional. May I read, Millard?
Okay. We have also.
69.
Rule page 747, 747. 747. এই বইটা দিন না জুডিশিয়াল প্রেসিডেন্ট কোথায় গেল রে
এটা ক্ল্যারিফাইড
Milord, provisional pension where departmental or judicial proceeding may be pending. No gratuity shall be paid to the government servant until the conclusion of departmental or judicial proceeding and issue a final order thereon. So I cannot give. Why it is
also, I think, decided because
no provisional
Supreme
pension.
Court has said that the Gratuity Act will override all provisions.
Section.
We may be wrong.
No, I am not, Millard. I cannot say like this, Millard. But my understanding, subject to what my lords will say, Millard, this rule, whether was considered by the Honorable Supreme Court, this particular rule in the present facts and circumstances, why, Millard, the gratuity can be only withheld, Millard, under the Payment of Gratuity Act, Section 4, subsection 6 of the Payment of Gratuity Act. But here, Millard, it says whatever may be the consequence if it's a judicial proceeding. Millard, if your lordship, my lord Justice Chatterjee, Millard, criminal procedure code পুরনোটা আছে? পুরনো criminal procedure কোডটা আছে?
No, CBI proceedings is judicial proceeding.
Yes.
Okay.
So, Millard, today, no gratuity means it's a mandatory. The rule, Millard, is still in vogue.
But we have a question that whether Gratuity Act will overrule this rule or not.
Millard, Central Civil Service Rules, Pension Rules, Millard, 1972.
Gratuity Act.
Millard, kindly please. Millard,
Where is your punishment order in respect of Ratanlal was stoppage of increments? Now thereafter this proceeding has attained finality.
Yes.
Now you are saying that no, I will.
No, I am saying
You are saying now that
yes.
In view of 69C.
Yes.
I will not disburse gratuity to you. Why? Because criminal proceedings.
No, because Millard, I cannot, Millard, I have not, I have, my action is not painted with any malice or imagination. I derive strength from 69C. It clearly says Millard, that
so
no.
Your argument is we will not pay a single thing because judicial proceeding is pending. This is
as I say because I had it been a case like
now we have heard you. We will ask for his answer. No, then you will argue as regards.
He is not representing Ratanlal. His case is different. He wants it to take it in a separate.
No. At one stage we are saying, my lord, after this,
I am giving a provisional pension. We have been discharging with releasing provisional pension. He is getting that Ratanlal. My senior friend is not Millard representing Ratanlal. All along he has been saying. That is why he said Maniklal should be treated in a different compartment.
All the cases originated
I will deal with this submission also.
And I was the author of Maniklal court. That is why I intervened sometimes.
What is your answer to this argument of Mr. Basu?
Milord, actually,
the answer is
Milord,
proceeding. You have retired. You have been imposed the punishment. Then, when you have retired, what is the rule? That whatever is the punishment that has to be deducted and remaining payment will be made. It attains finality. His argument is no. Even if that has gone, it has gone. Now I will not pay to you since you are involved in another proceeding. Why? Because 69C gives me that authority. That is your argument on that point.
My argument was there, my lordship remembers. I was on the.
No, I don't remember. And please tell us why this analogy will not be accepted.
After this judgment of course, I have to be very cautious. After this Ratanlal judgment, I did not depend on it. Tapan Das. I did not depend on it, but I relied on it. And that was my, of course, difficulty because they immediately went to Supreme Court. And I drafted the affidavit in opposition there. Actually, Milord, my submission before your lordship was that day. That till such time, I relied on documents. Still, I can rely on all the documents.
You answer on the proposition of law. You tell us.
Yes, Milord. Now, after this, I say Rule 58, he has also clearly said, Rule 58 does away with all the hitherto applicable government rules upon a upon a government servant. Rule 58 of BSNL CDA rules.
Yes.
And of course, Supreme Court also agrees on that, says on that. Rule 58 is
296, page 296.
296, my lord.
Rule 58.
296. Any rules corresponding to this rule in force.
Which rule you are saying?
Oh, yeah.
Rule 58 of BSNL CDA rules.
BSNL rules.
BSNL CDA rules, my lord, that is at page
2006 rules. 2006 rules.
2006 rules. That was.
We have not been given that rules.
Actually, in my brief, it is there.
Tell us what is there in the rules?
No, the Supreme Court of
58, tell us.
So BSNL CDA rule says, my lord, that was effective from 10/10/2006. I argued before your lordship that rule 30, as per setting up order that was published on 1/10/2006, BSNL was formed. Only one day prior to that, that was formed, and they say clear stipulation was there. Clear stipulation 460. Clear stipulation was there.
Don't reopen the issue. It has been decided by the Supreme Court.
That was decided by the Supreme Court.
Court.
Now
you give the answer that the authority is denying payment of the gratuity and the rest part
that's
of
what.
the
Yes, ma'am.
pension on the plea that a CBI case, a judicial proceedings is pending against you. Now, what is the answer?
In my case, my lord, in my case, I was telling your lordship that that the charge sheet was.
We are on.
I am on Manik Kaur, my lord. Manik Kaur, lordship for the timing opens the word Manik Kaur.
Manik is also same. In one proceeding exonerated, in the next proceeding he was penalized.
No, we could not complete because the Honorable Tribunal quashed the charge. And I came before your Lordship's court, and the Honorable Lordship's court, my lord, that is this matter. The affirm the Caste order. Pending. The order before is your Lordship under challenge. The order of the tribunal quashing the charge sheet issued against Maniklal by way of a defermental proceeding, Miller, that is a subject matter of challenge in the instant writ application. And now, in view of the Supreme Court's order in Tapan Das, I say that this issue is Romo Nes Integra 2006 will be made applicable. If that is made applicable, then what is my recourse? I can revive the proceeding. Why I can revive the proceeding? Because departmental rules, I have shown to your Lordship that even if the person is retired, I can start the retirement proceeding. By reason of the judicial.
So you pass an order to the defendant. Your authority have not passed any order in lieu of the submission which you are making.
No, I can't because when the charge sheet was set aside by tribunal, and when I questioned this order before your Lordship's court, and which is pending the instant writ petition, how could I take an action, my lord, against this gentleman? Because it is continuous proceeding. I issued a charge sheet against Maniklal. That was quashed, set aside. Immediately I came before your Lordship's court. That is pending, yet to be decided. And which is before your Lordship just now, there is the instant writ proceeding. And if the Supreme Court has come in aid of us, my lord, I can take strength from this order. 2006 will be made applicable. The entire foundation or premise of the order passed by the CAT, tribunal, taking a note of Justice Stand and Division Bench judgment, that goes. Now, Mr. Dash, my learned senior friend, can argue or might say that my client is powerless so far as the new proceeding is concerned. I say no. With humility, my lord, because the rule 2006, my lord, which is still in vogue, these rules are still in vogue, it empowers me, my lord, to start a proceeding. I could not come to a logical end.
Pertaining to the said instance.
Absolutely, absolutely. Because it is a financial charges, these cannot be stale charges. CBI, or my lord, if your Lordship says, today, Ratan Krishna Miller, my learned senior friend, is not.
Yes, Mr.
Ratan Krishna Miller, he has no answer.
I was confining myself to the gratuity only. of Manikot as per Rule 61.
Your lordships were asking me Ratan Lal. He is
Actually,
not at.
two things. One thing, continuation of the proceedings, Maniklal.
Yes,
Continuation of proceedings and payment of gratuity and pension.
payment of gratuity, Milord.
Pension. Two things.
Two things, Milord. Yes, yes, I am asking for two
not
things.
explained.
First of all, let us look.
Maniklal and other.
Let us look.
First exam. Second test. No.
My lord, look to the Rule 61.
Cat course.
My lord looks to Rule 61. He is absolutely guided by Payment of Gratuity Act. And that Rule 61 1C of the CCS pension rule is not applicable to BSNL employees. Neither any of the CCA rules are employed to the applicable to the BSNL employees below. After 1/10/2006, that is the Topundar's judgment, that is the Supreme Court, Honorable Supreme Court has said. Now let us see 61.
Why Honorable Supreme Court says that in respect of BSNL employees,
Lordship,
CCS rule 1972 will not be applicable.
Lordship, they say.
Maybe we have missed that line.
Lordship, the judgment at page 3. Judgment at page 3.
Yes. Yes.
Acha, before that, there is a reference of Rule 58 at page 3 at the top. So, but I go to 4. Learned counsel for the respondent submitted that the charges relating to the year 1999 to 2001.
Where are you reading?
Below.
Where are you reading?
Oh, Topon the judgment below. Page paragraph 4.
Oh, yeah.
Yes, tell us.
Learned counsel for the respondent submitted that the charges relating to the year 1999 to 2001 were prior to coming into effect of the 2006 rules, and thus rightly the High Court has held that legally the proceedings, if at all maintainable, had to be conducted under Rule.
This is the submission of the respondent.
And thereafter their lordships straightway said, having considered the matter, we find substance in the contention of learned ASG. Thus, the findings in the impugned order with regard to 2006 rules not being applicable for conducting a disciplinary proceeding for an employee who was under the Department of Telecommunication prior to creation of the petitioner company in the year 2006 would have to be under the 1965 rules is set aside. Partly it was set aside and shall not be relied upon applicably.
Now this setting aside has revived the entire charge sheet. High Court held in your favor.
Then
Supreme Court has said that no, 2006 rules are not applicable. This finding given by High Court
that is set aside. That is revived.
That is
that
right.
revived.
So they initiated the proceeding under 65 rules. Tribunal quashed it. So their stand of the initiation of the proceeding under 2006 rules is proper.
But Milord Lordship,
step by step. So the initiation of proceeding against them is proper. If it is proper, then you have been exonerated from the departmental charge sheet. One charge sheet you have been exonerated.
That is the main thing, Milord.
There is another charge sheet. That is another criminal proceeding. I'm not understanding this. He has said.
That I'll argue.
Please come to the note. Column 1 says exonerated. Please note. Have you got it?
Yes, Milord.
You have not got it. This one is there, sir.
I have not given it.
Yes, that was I was trying to place
so, his proceeding which was initiated under 2000.
Milord, the CBI charge sheet was in 2005.
Okay.
And this department.
Okay, one by one.
What?
One by one, let us. Now let us discuss regarding continuation of the proceeding.
No.
Later we shall come into the payment. Continuation of the proceedings. entitled to invoke 2006 rules.
Lord, under
You hear kindly. It will benefit you. So you approach the tribunal that the proceedings initiated invoking under 2006 rules is bad. Tribunal accepted your contention. Quashed the proceedings. Honorable High Court also accepted your contention.
Lordship.
They went to the Supreme Court. Supreme Court says, well, no, they are right. They have rightly invoked 2006 rules. So the proceedings initiated against you shall revive.
Lordship.
Shall revive.
Levites.
So they have the right to take action.
Lordship.
What is your submission? So it is admitted.
That is why I started by saying the Supreme Court at the end. Supreme Court at the end concluded by saying a quietus shall be given to the entire controversy.
In the particular top,
we are also dating.
Thus, in the particular fact of the present case.
That is why I was going to tell you, Lordship. Yes.
This order, this part of the order has not been given effect to in respect of all. In the particular case, in this case.
Why? There was a criminal case against that gentleman.
No.
There is the
Criminal case is there, Miller. That is what I was. Lordship, hears me for a moment. What is that charge sheet? Miller, in 2005, I said, CBI issued a charge sheet. Now, this charge sheet, following the CBI and at the instruction of the CBI, the department issued a charge sheet in 2007, 5/11/2007. All the charges for 5 years, inquiry proceeded. Inquiry officer found that it is not proved. The disciplinary authority also, by his order dated 28/4/2012, 28/4/2012, date is important, Milord. They exonerated me, and I was in the department on 30th, and 29 CBI put the charge sheet. CBI, at the instance of the CBI, the charge sheet was issued by the department. That is nothing but the replica of the CBI charge sheet.
What is
and,
that?
And Milord, what I did.
Is that charge sheet?
What?
Second charge sheet.
Second charge sheet is the replica of the CBI.
আচ্ছা সেটা কোথায় আছে?
আছে Milord, আছে. That is, I'm giving the lordship. They have given. It is their paper. They have given. Departmental charge sheet for second, page 123. Page 123. And Milord, my client attended the inquiry, but all the necessary documents are lying with the CBI court. 123.
You just, Mr. Banerjee, page 55 is the first charge sheet.
Yes, page 199, first charge sheet.
Yes.
55 first charge sheet. Second charge sheet, where is the second charge sheet?
Second charge sheet is at 123, Milord.
123.
Yes, it is his application. It is his application. I'm sorry, Milord.
123.
123. It is his application.
55 is the second charge sheet.
Milord, I was sorry. I was all along thinking it is my
55 is the
application.
second charge sheet.
4th of April 2012.
Yes, 4/4/2012.
This is the second charge sheet.
Yes.
Page 122.
4/4/12.
That is the replica of the CBI charge sheet.
Maybe.
Oh. The second charge sheet on proceeding initiated on the basis of page 55. From that he has been exonerated, Mr. Basu.
The page 55
is
dated
dated 4th April 2012.
That is the second charge sheet.
Right. In this charge sheet, he has been exonerated.
In this charge sheet was quashed by the honorable tribunal.
No, then exoneration is
the first charge sheet.
Where is that?
First charge sheet.
5/7/2007.
First charge sheet.
195, 195.
195 না 99 যাই হোক আপনার
195
195 আমার পেপার বলে কি ভুল হবে?
এটা 2007 এটা 2012 তাহলে এটাই পাস।
195
199 ঠিক আছে 195 In my copy it is 199. Yes. And my lord, the inquiry officers not to 200 and কত 224
Now the tribunal quashed which charge sheet?
Charge 4/4/2012.
55.
Page 55 was quashed.
55 was quashed.
And from the first charge, he was exonerated.
Exonerated. Yes.
Milord, inquiry disciplinary authorities order at page 227.
এইটা quash করো। Supreme Court order নেই ভাই।
Supreme Court, he never approached Supreme Court.
He was exonerated in connection with page 55.
না, exonerated
5 is the second charge sheet, 195.
195
Exonerated from 195. That is 5/11/2007. Data ঠিক আছে?
ওটা 2007 এ।
Yes, he was exonerated. And 55 is 4/4/2012, which the Honorable Tribunal set aside, against which Milord I came before.
Just now revived.
Yes, now I came before your lordship. Now, আপনি মাঝপথে জজ সাহেব জিজ্ঞেস করেছেন, স্যার আমার সেই উদ্ধত নেই আপনাকে থামানো। আপনার মতো ব্যক্তিত্ব।
What I was, yeah, একটু বলিনি। What I was saying, Milord, this inquiry and everything will show I have not caused any loss to the department, even a copper. And Rule 61, payment of gratuity act.
We have tried our best to explain. We are seeking an answer from you. Say that you are not agreeable to answer us. We will leave. We will now go to. We request